Uh, Good morning. Let's just go on the record immediately, given the order of today's proceedings. Welcome to the January 25th meeting of the Board of Utah Oil, Gas, and Mining. This morning we're going to be doing things a little differently. We are foregoing the briefing session because we have such a large list of docketed items, and we're going to just go straight into the docketed items. But before we do that, I guess I should ask, is there anyone that would like to make public comments? If so, could you please come up to the microphone and state your name and let us know your comments? Seeing none, I guess we shall proceed into the docketed items. One other order of business before we do start with the first item is the order of the items is different. We've decided to do them differently than was posted. We'll proceed with item number 6 first, and then go to, and that is docket number 2023-004, cause number 132-09. Then we will go to items 2 through 5, then item 7, then item 1, then items 8 and 9. So given that, we will begin with item number 6, which is again docket number 2023-004, cause number 132-09, in the matter of the request for agency action of OVINTIV USA, Inc., for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting owners in the Akawina, Utah 3-27, 3-2-27-34-7H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised all of sections 27 and 34, Township 3 South, Range 2 West. I'll now ask for appearance of counsel.
Fred McDonald of Counsel of Lear & Lear on behalf of the petitioner, OVINTIV USA, Inc.
Elizabeth Harris on behalf of the division.
Thank you. Over to you, Mr. McDonald.
Thank you, Mr. Chairman. Members of the board, we're going to proceed. This is going to be a different matter for you to hear today, and there's going to be several like this. As you are aware, because the docket was so crowded and due to the staffing issues with the divisions and their attorneys, this matter was originally scheduled or asked to be heard by a hearing examiner. And because of that situation, a hearing examiner could not be provided. So with the consent of all counsel and the board, this matter is going to be presented to you through affidavit on testimony. And then I'm also going to clarify some issues and some housekeeping matters. The affidavits of the witnesses here were provided to you about 2 weeks ago, or were filed with the board secretary. And rather than going through all of the rigmarole of what happens in a compulsory pooling hearing, you've been through enough of them. You know what the testimony is like. And basically what happens in this situation is that the affidavits outline exactly the same testimony that we would provide if the witnesses were here. You're going to find out today that OVINTIV's witnesses are available because we have other matters today, but when this was set up, we thought that this one was going to be separate. So just so you're not confused, even though the witnesses are available today, this particular matter is going through by affidavit. On some housekeeping matters, I want to go through this first. And by the record, the affidavits are from Peter Burns, who's the senior land negotiator for OVINTIV, and Kendall Brown, who's the reservoir engineering manager for the Uinta Basin. And again, they outlined all the things that would normally be testified to in a compulsory pooling hearing. On a clarification issue here, first, as outlined in OVINTIV's motion to file a supplement to Exhibit B, certain owners were declared as non-consenting owners under an order issued by the board on June 12, 2013, in cause number 139-104. The well involved with that was a vertical well that was drilled, the Moon 127 3-2 well, which is located in the southwest quarter, northeast quarter of Section 27, which is at issue here, which was drilled by Newfield Production Company, OVINTIV's predecessor in title. Under that order, that well also began producing in 2010. Under that order, the non-consenting owners were subject to a 300% risk assessment in favor of OVINTIV, or Newfield at the time. As outlined in Mr. Burns' affidavit, that well has not reached payout yet. However, pursuant to the 139-134 order, which was submitted as part of Exhibit B, the 139-104 order was to be vacated, and as also outlined in Mr. Burns' affidavit, OVINTIV waived any further recoupment from the non-consenting owners identified in the 139-104 order as of June 1st, 2022, the date of conversion. Furthermore, the production from that vertical well converted from a sectional basis to the two-section drilling unit basis, also effective as of June 1st, 2022. The 139-104 order was referenced in, and a true and correct copy of it was attached to Mr. Burns' affidavit. In addition, it was the supplement to Exhibit B that was filed a couple weeks ago. Unfortunately, at the time the request for agency action in this cause was filed, neither OVINTIV or I were aware of the 139-104 order because the division's Data Explorer search panel reflected only one order that was entered in cause number 139-104, and that was dated August 26, 2013, and that order pertains to lands other than Section 27. It's also the August 26th order is the only one that was referenced in the 139-134 order. So to kind of clarify for you, there were two orders entered in 139-104, one that pertained to Section 27 but wasn't shown up on the website, and the other one which was showing up on the website and was referenced in the other one. So that's why we didn't know about it and we didn't address it in the request for agency action. Even though it's not specifically addressed in that request for agency action, the request for agency action does provide that further recoupment from any non-consenting owners in that moon well was to be waived as of June 1st, 2022. And therefore, the 139-104 is really just an administrative necessity to remove it from the board and the division's records. Also in the request for agency action, one of the requests obviously at the end is such other further and relief as may be just and equitable under the circumstances. And so the vacating of that old order, given the conversion, is again just as necessary to get the records straight. Didn't want to confuse you too badly on that, but it wasn't addressed in the request. So for procedural matter, we're making a motion to amend the request that part of the relief that we're requesting from the board is that 139-104 order is vacated as part of this. And I'll verify that with you at the end if that's granted. Next, as the record will reflect, none of the parties identified in the request for agency action as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or made an appearance today. Consequently, pursuant to Utah Code, Admin Code R641-104-150 and R641-108-400, OVINTIV will move to enter an order of default against them. Is there any objection from the division to that?
No objection, thank you.
I don't know if the board wants to rule on that now or hold off on it.
I would entertain a motion to rule on the order of default.
I'll make a motion to rule on as requested.
I'll second it.
All those in favor say aye.
Aye.
Let the record show that was unanimous. Proceed.
Thank you, Mr. Chairman. Also, as a matter here, because of these affidavits, I want to confirm that the board recognizes Mr. Burns and Mr. Browns as experts in petroleum land management and petroleum engineering, respectively, for purposes of this cause. As you may recall, they've both been recognized in those capacities as experts in other compulsory pooling hearings before the board.
Division, any concerns?
No, we'll stipulate to those being admitted as experts.
Board, any concerns? Okay, so admitted.
Thank you, Mr. Chairman. Finally, I want to confirm the board received the supplement to Exhibit Z filed on Monday and the second supplement filed yesterday. Those are simply the updates of the return receipts confirming receipt of the request for agency action by the parties sought to be compulsory pooled. Did everybody receive that? Or is it part of the record? Okay. Exhibit Z is supplemented, was not addressed in either Mr. Burns or Mr. Brown's affidavits. As I mentioned, it represents the return receipts to the no non-consenting parties and any unreturned unclaimed mailings to those parties. Based on all of this proffered testimony and on Mr. Burns and Mr. Brown's affidavits, I would move for admission of Exhibits A, B is supplemented, C through U, and Z is supplemented into the record.
Division, are there any concerns, given this is a slightly different situation with the affidavits?
If I can, this is the first time seeing A and Z, so if you can just give me 1 second to,
Yeah, A are the resumes of the two witnesses, and B is the 139, 134 order, and the supplement to it was the 139, 104 order.
I've got Exhibit A as Matt Pilkington's.
No, that's next month.
Am I
That's
in
a
the
different
wrong month?
matter.
Well, that would certainly explain why I'm not finding the right one.
Now, this one is Mr. Burns and Mr. Brown's resumes. I can show you a hard copy, Liz, if you want.
I think in the board book, we've got the wrong exhibit on that matter, but I did review that from your exhibits
But at least you have that
originally,
one.
and I'm okay with that. So no objections. Let's just make sure we have the right, for the board, the right ones.
B,
C through,
B, U?
C through U.
Yeah.
Yeah, the hard copies of mine show the Exhibit A is the resumes of Mr. Burns and Mr. Kendall Brown, and B is the 139, 134, and as the supplement was 139, 104 order.
Sorry, I didn't have that in front of me.
Maybe I'm looking at the wrong one.
I show it as correct in the book.
Looking at 132.
In the board book.
I swear that's what I'm looking at. I'm double checking, but, okay. I did review those. We're good. We'll just double check.
Okay, I think in the division, do you have any objection to the admission of those into evidence on this one?
I think-
All those exhibits?
I think it's the wrong one. I think it's. Not that one.
That's our matter right there with the
This one.
setbacks.
This is the one.
One before it.
Here, let's see if you want to look at the hard copies?
No, I saw the hard copy. I'm just trying to figure out technology.
We have no problems with Mr. Burns and Mr. Brown.
Yes, they're great. Sorry. Yeah, there we go.
Division, are you comfortable with all those being admitted?
I'm sorry, yes. Yes, we have no objections. Thank you. Sorry
Okay.
about that.
Board, any comments or concerns before I admit these? Okay, yes, those can be admitted as evidence.
Thank you, Mr. Chairman. With that, that's my presentation. If the board does have any questions about this process, we hope you find that this procedure will be helpful to expedite resolution of board dockets and used more frequently in the future if a hearing examiner is not available, as it was in this particular cause. And so, I know this is your first exposure to it, but it is a process that might help expedite things for the board.
I must say, I do like the streamlined process when the docket list is heavy. I'm at a little bit of a loss. I want to make sure I give everyone a chance to have their say, though, if there are any concerns. So I will go back to the division one more time. Anything you would like to say?
Oh, thank you. From the division's perspective, this is a very streamlined and easy process as well. It's very convenient to have the testimony in documentary form to verify that everything that needs to be there is there. So I think in general, the division is supportive of this process if the board chooses to move forward with it. So other than that, we have no objections to this compulsory pooling.
Thank you very much. Do you need to make any more closing statements, or was that it?
I don't, Mr. Chairman. We just submitted, again, on the basis of the affidavits, the proffered, that I've proffered today, the testimony, and ask that the board approve the request as submitted.
Excellent, thanks. Because this is a little out of the ordinary, I would like the board to adjourn to another room briefly to deliberate, and we'll hopefully be back shortly.
Okay, one other point, Mr. Chairman. I just want to make sure that the board rules on the motion to amend the request on that vacating of the 139-104 order as well.
Okay, thank you very much for that reminder. We are off the record, and we'll try and be back as rapidly as possible. Thank you. We are back on the record. Thanks for your patience. Before we proceed, just a couple of comments and observations that the board would like to make. I think we can all acknowledge, everybody here, that this is a somewhat unusual new process, and we're all getting comfortable with it and learning how to optimize it. But the board does have significant comfort that the division has reviewed all the documentation and has no major concerns. I do think in the future we would prefer that these sorts of relatively routine matters without a lot of contentious issues around them be heard before a hearing examiner if possible, rather than go through this process. I think that would give everyone more comfort in the process. I also think, again, we're still trying to get calibrated on this process, and I think the board would be a little more comfortable, Mr. McDonald and others that are listening, that if a little more time were spent laying out just at a very high level the framework of the argumentation and the evidence and the documents submitted, and tie those together. It doesn't have to be a really long, exhaustive presentation, but I think that might be a little more useful for us. And lastly, we would like, Mr. McDonald, could you restate exactly the relief that you are requesting for the board?
Yes, first of all, Mr. Chairman, I do have to do another housekeeping matter. I want to make
Oh,
sure
yes, I
that
apologize,
the
yes.
affidavits of Mr. Burns and Mr. Brown are accepted into evidence as well.
Division, any concerns?
No objections.
Board, any concerns? Seeing none, those are admitted.
Right, thank you. The relief asked for, Mr. Chairman, is, again, the compulsory pooling of all interest in the drilling unit that's at issue, which is sections 27 and 34. The declaration of the parties identified in the request for agency action as being non-consenting owners, that the board adopt the joint operating agreement that was submitted as exhibit, I can't remember the exhibit number right off the bat, but the exhibit that was submitted under Mr. Burns' testimony to govern the operations between OVINTIV and those parties, and for the imposition of a 300% risk assessment award to OVINTIV and the consenting owners. And also with the amendment that we requested this morning, the vacating of the 139-104 order dated June 12th, so that matter is cleared off the docket given the conversion and the waiver of any recoupment under that order.
Thank you. Division, any concerns with that request?
No concerns. And Mr. McDonald and I have already discussed that any order would need to specifically state that the recoupment is being waived and also to vacate that underlying order. And so we've already agreed. We'll make sure that's in there.
Thank you. Board, any last questions or concerns? In that case, I would entertain a motion.
I move that we accept the request for agency action as stated.
I'll second that motion.
Thank you. Before we vote, any last comments from the board? Seeing none, all those in favor say aye. Aye. Let the record show that was unanimous. Thank you.
Thank you, Mr. Chairman.
Oh. Mr. McDonald, would you please prepare the order?
I will.
Thanks. So, do I do all these because they've all been consolidated? Do I read all of these?
No, I would just say we're going to, based on the order of consolidation,
All right, the next items on the agenda are actually a series of consolidated docket items. There's 4 of them. Docket number 2023-001, cause number 132-07. Docket number 2023-002, cause number 132-04. Docket number 2023-007, cause number 132-11. And docket number 2023-008, cause number 132-12. I'd now ask for appearance of counsel.
Yes, Mr. Chairman. Mitch Mayo of Lear & Lear, PLLC, on behalf of XCL Resources and XCL ASSETCO, the petitioners in these causes.
Trevor Gruelle with the Utah Attorney General's Office on behalf of the division.
Thank you. Over to you, Mr. Mayo.
Thank you, Mr. Chairman and members of the board. And as everyone stated today, thank you for considering this fairly novel procedure here today, at least in this administrative body. As was stated, there are 4 requests for agency action at issue today brought by the petitioners, XCL. Cause numbers 13207, 13208, 13211, and 13212. Just yesterday, the board ordered these matters consolidated for purposes of this hearing only. Each of these matters will still have to survive or die on its own merits. Each will produce a standalone order. But for purposes of facilitating this discussion, especially given the novelty of the procedure here today, they were ordered consolidated. As you heard from Mr. McDonald a few minutes ago, these matters have proceeded as all compulsory poolings hearings you've heard, with one exception, and that's that there's no live witness testimony. The live witness testimony has been reduced to sworn written declarations that have been filed in these causes. If you'd like more of a background on the reasons for the procedure today, that's laid out in the motion to consolidate for hearing on filing cause 13207. There are 2 witnesses, the same 2 witnesses that are testifying on behalf of each of these requests. Mr. Kevin Ananson is the Vice President of Business Development and Land for XCL, and Mr. Mark Gravy is the Executive Vice President of Reservoir for XCL. Mr. Ananson will testify as a fact witness, or his declaration testimony is submitted as a fact witness. Mr. Gravy, his declaration is offered as expert testimony in reservoir and general operations, presuming stipulation from the division and approval by the board. Mr. Gravy has appeared before this board and been recognized as an expert in those fields, most recently in cause 600-04.
There's no objection from the division for this, these statements provided by declaration to be as expert testimony.
Board, any concerns about these expert witnesses? Seeing none, they're recognized as expert witnesses.
Thank you. This board has heard anecdotally and through requests coming in here over the last several years about operators engaging in batch drilling. And these 4 requests represent a pretty significant attempt at batch drilling by XCL. Collectively, these 4 requests seek to pool non-consenting interests in 23 wells drilled within 4 drilling and spacing units, 2 1280 units, and 2 accompanying 2560 units. Although the declarations on file in each cause contain all the necessary information to approve the request as pleaded, given this procedure, I'd like to spend a few minutes and go through some of the key components for granting a force pooling that you need to feel confident in. Those things to me are, who are the parties you're seeking to pool? Were they given an opportunity to elect in the original well? Were they provided adequate notice of this hearing and of the request on file? Are the JOA terms reasonable and just? And what is the acreage-weighted royalty to be imposed? And so I'll go through each of those somewhat briefly to try and keep this condensed for the board. Hopefully it'll keep on track, and if there are any questions, if you'd like to ask in individual sections or if we'd like to move forward and ask all at the end. So the first question, who are the parties being pooled? And the answer to this is identified on For the non-consenting parties being pooled in each unit, those are identified in Exhibit 2 to the request for agency action. For any of the estates that we're seeking to pool out of an abundance of caution, each of those is identified on page 3 of their respective request for agency action. And at the hearing today, all of those parties are being pooled in their respective matters, with a few clarifications. Over the course of this process, since filing and mailing out notice, there have been contact from a couple of people, and they need to be removed from the request. In cause number 13208, there are no changes. The parties identified in the request are the parties being pooled here today. For cause numbers 13207, 13211, and 13212, there are a couple of parties that we need to remove on the record here from the request. The first is a party identified as a non-consenting party in each of those matters, Emily Lazama, trustee of the Noble Family Trust. She filed a protest, actually, in this action, or an objection, stating that she had been traveling internationally and hadn't had time to make a determination. I'm paraphrasing. XCL immediately reached out. She has since leased her interest to XCL. And so at this point, she's also withdrawn her protest formally before the board in this matter. So I'd like to just make a formal recognition that she is being withdrawn by XCL from the request and will not, that the Noble Family Trust will not be pooled as part of this action in those 3 matters. Also in those 3 matters, 13207, 13211, and 13212, one of the estates is being removed, and that is the estate of Oscar Nelson. We were contacted, myself and XCL were contacted about a week and a half ago by Oscar N. Nelson, who is Oscar Nelson's son. After some title clarification and some checking of the initials in the names, it was determined that the interest is fully leased and is no longer appropriate to be included in the request for agency action. So with those 2 changes, the parties identified in the request for agency action are the parties that the board is pooling here today. Question number 2. Were each of these parties given an opportunity to elect in the wells when they were drilled? And the answer to that is yes. The declarations bear that out pretty clearly. As you'll see in reviewing those declarations, complete well proposal packets started going out in early summer of 2021 and were sent through November of 2021 for the 23 wells. Copies of those well proposal letters sent to the non-consenting parties identified are attached as petitioner's exhibits in each cause. Second question, were these non-consenting parties provided adequate and sufficient notice of the request for agency action on file in each of these causes and of the hearing here today? And the answer to that is also yes. Standard practice, rule, and order of the board, XCL provided mailed notice and published notice of the request for agency action and of the opportunity to elect to participate. And actually, both methods of notice were effective in this matter. The Noble Trust had received the RAA at its last known address of record via mailing. And another, one of the estates that isn't being removed, but someone who contacted us with questions about their parents' interest that was included, they actually heard about this through their attorney via published notice. So the published notice was received by the non-consenting parties, and the mailed notice was received by the non-consenting parties. Furthermore, more important than that for this proceeding is any and all objections that were timely filed have been withdrawn voluntarily, such that there are no pending objections or responses to any of these causes from any of the parties duly noticed. The third key question for the board today is, are the JOA terms presented by XCL here and presented by XCL for the board to adopt in this matter, are they just and reasonable? The answer to that, I believe, is yes as well. This is, XCL uses a standard form, AAPL form 610 1989 JOA form. The terms have been modified slightly for the business operations, the given well, non-consent penalties, stuff like that. But the terms in this JOA have been voluntarily agreed to by numerous parties, including in the units at issue here today. And the board has adopted and imposed JOA terms very similar to these in numerous forced pooling actions. Furthermore, there are no objections to the JOA terms of record And so it would be XCL's position, clearly, that the JOA terms are just and reasonable and should be imposed. Finally, the last question is, with force pooled parties, what interest will they receive? The acreage-weighted royalty to which they're entitled. For the matter 13207, those parties will receive a 16.826,727% acreage-weighted royalty. For matter 13208, those parties receive an 18.451392% acreage-weighted royalty. For matter 13211, 15.060719%. And for 13212, a 17.581900%. Now those lines are close together, but the acreage-weighted royalties are significantly different from 15% to 18.5%. As the board's aware and as described in the exhibits and in the declarations on file, the acreage-weighted royalty calculation is taken from statute and regulation, and it's simply a function of more 12.5% leases in some units, more 20% leases in other units. But those are the acreage-weighted royalties that will be assigned to the parties if the requests are approved. As Mr. McDonald did, I'd like to note that none of the parties identified as non-consenting parties have objected and sustained that objection through this hearing. And as Mr. Begley, Chairman Borden asked for public comment at the beginning of this hearing, none have appeared or made an objection at this hearing either. With that, under Utah Administrative Code Rule 641, 104, 150, and 641, 108, 400, I'd like to move to enter default against those parties here today.
Division, are you comfortable?
The division has no objection for the petitioner's request that a default be entered based off of the lack of objections, and the division overall is supportive of the requested relief apart from the current motion for default.
Board, any questions or concerns about the default?
I have just a couple of questions. What was the weighted average for 07?
07, I believe, is 16, rough or exact?
Just rough.
16.83.
The other question is the JOA the same JOA you're using for consenting people? It is no more punitive against the non-consenting people?
That's my understanding. Clearly, there's a clarification there that needs to be,
Right.
and that's that each consenting party negotiates for terms specific to them. So without a consenting party on the other side to negotiate the terms, my guess is you and I may see that and say, it is more punitive, but the reality is there just wasn't someone on the other side of the table negotiating, if that is responsive. It's my understanding the terms are the same, but given the fact that there are a number of consenting parties who have voluntarily signed the JOAs, I don't want to tell you that some of them didn't negotiate a better contract.
Thank you.
Yep.
Any other questions, concerns from the board? Yes.
So these 12 and a half, are those just private leases that were just old leases held by production years ago?
They must be. It's
There's no like state or
by statute, state,
Is it
federal,
excluded?
tribal, all have to be excluded. The only things that can be included are leased fee that are leased prior to commencement of drilling. So once the drilling starts, that's kind of the bucket of leases. And I think the idea is arm's length transactions between similarly situated parties.
Those are just old arm's length transactions.
Those
That
are.
a new non-consenting parties, or unlocatable parties going to be subject to some, 20, 30, 40-year-old leases. But that's the way the statute is, so we can't really mess with that. But I've just never seen us go down below 16%. 15%.
Is
Yeah.
Yeah, it's and I think maybe the response to that would be, clearly mathematically, everyone in the unit is getting an average of 15%. So even though these parties are getting imposed, if we gave them a 1/6 royalty, they would be, for not responding and not consenting and not agreeing to participate, they would be getting more than the average landowner gets in
Yeah.
those sections. So,
And I didn't research a lot. It's just interesting, there's so many old leases held by production. Well, why are there unleased parties?
well,
Or
it's
unlocatable parties this late in the game?
that's a really good question. I think in some units there are, well, I mean, as the board's well aware, horizontal drilling and holding big blocks of leases is a relatively new concept in Utah, maybe the last decade. Before that, it was almost exclusively 40-acre or rule of capture wells, and you could see patchworks of unleased interest in units. You know, in addition, some of these interests have been unleased from time immemorial and will be unleased 40 years from now. So I guess that's kind of my
Yeah.
anecdotal response would be.
Yeah, I don't know, because this area, I think, was just, 640 spaced areas. So I don't, yeah. Anyway, just curious.
Yeah, I mean, I guess you know, yeah,
Yeah, I don't expect you to have an answer, just
thanks.
Okay.
Oh, one quick, sorry.
Sure.
Do you know, by chance, what the percentage non-consenting or force-pooled interests are in these units?
I can look it up really quickly in the request. I think it's identified in each of, I know it's identified in each of the requests. I'm not
I
sure
mean,
where.
are we less than 2-3%?
I think the biggest of the units is almost 3%,
Okay.
but the smallest is around 1%.
Okay.
So they're, in that.
That's good.
Yeah, okay. And I've got specific information for each of the requests, names of the wells. If the board is interested in that, going through a little more detailed. I'm trying to recognize Chairman Borden's comments to Mr. McDonald, but also respect the purpose of this, which is brevity. So with that, I have one last matter, unless there are further questions about that.
Should we still need to address the default request, or do you want to do that matter before we vote on that?
Well, we can, to me, asking for default and asking for approval it's almost approving the same thing. So it's up to you and board counsel to.
Okay. We'd prefer to do the default right now, so, board, are there any other questions or concerns before I would entertain a motion on the default order? Or do we need to deliberate on that? I would entertain a motion then.
I move we approve the default order stated.
I'll second that motion.
All those in favor say aye. 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 The record should show that was unanimous. Mr. Mayo, back to you. We do need to enter those exhibits at some point.
Perfect timing, perfect segue. That's my last, absent any further substantive questions about these, which obviously I'm available for, the last matter of housekeeping is the admission of exhibits. So I'd move for exhibits, and I'll do this collectively. In cause number 13207 and 13208, the exhibits A through K and the declarations on file in each of those respective causes. And in causes 13211 and 13212, exhibits A through J and the declarations on file in those causes.
One moment, I've got a lot of check boxes. That
You're
need
doing a
to-
very, I know, I saw that checklist, it's massive.
While I am doing that, division, again, given the unique nature of this, any last comments, questions, concerns about these exhibits that we are
No, the division has no concerns with these four matters. The division was supportive of the board granting petitioner's request to have them consolidated into four, where they are so similar, both in terms of similar facts, not exactly the same facts, but basically the same law that was being applied in this matter. The division has reviewed all exhibits, has reviewed all requests in these four matters, and is comfortable with the requested relief. the division believes that due process was given to all of the non-consenting owners, whether they be locatable or unlocatable, both through the direct mail that was sent out to these individuals and entities, as well as with approval from the board, the notice by publication. And the division is satisfied that the requested relief, in particular, the estimated cost to plug and other aspects about this is accurate and reflective of how it should be.
Thank you. That again does give the board significant confidence in this manner to know that the division has reviewed all those documents and come to those conclusions. So much appreciated.
And the division will note that the Flaming Dragon Wells is probably the coolest well name that anyone has heard so far.
I must agree.
Must be really good wells, flaming, although they better not be flaring all that.
Not the
leave
flaring dragon, that's too much.
Again, given the unique circumstance, board, are there any questions, concerns before we admit all these exhibits, including the affidavits, into the record? All right, they are so admitted.
Okay. If there are no further questions, this was a unique development in Utah, and this was a fairly unique way to proceed with the request for agency actions here today. Without any further questions, I'd just like to thank the board for their time today and for patience and flexibility with this. I think this can and in my humble opinion, should be something that we work towards on uncontested matters such as these to conserve the resources of both the board and the division. So with that, I'd rest. Thank you.
Thank you. Division, any last statements?
The division echoes the sentiment expressed by petitioners. Assuming that petitioner will prepare a proposed order, the division will work with the petitioner to make sure that those individuals who were originally listed in the request for agency action as non-consenting owners, but who have since leased, will be removed from the order before it goes before the board for approval.
Do you want me to still get us to step out for deliberation? Just briefly. Okay. The board would like to just step out for a brief deliberation before we entertain a motion on this issue. Thank you for your patience. Okay, we're back, and we are still on the record because I forgot to go off the record, but we're all good. Before we proceed in our deliberations, I think a couple more questions came up, and I'd like to allow the time for board members to ask a couple more questions about these matters.
Mr. Mayo, I just have a couple of questions of interest. In future presentations, this is a new format for us. And so we're thinking about things we'd like to see and hear. When you're giving us the weighted average, when we're doing these multiples, would you also give us the percentage that the non-consent represents to the total unit?
Absolutely. I can look through and give you that now if you'd like, or at least a good ballpark. I think it's in the declaration spelled out, and I
Yeah,
can find it.
probably is, but I'd just like to have it on record here while I'm sitting here.
Perfect.
The other question I have is, what do you do about unlocatables that show up later? Are they considered pooled under this unit? Do you do a catch-all unlocatables for future, or?
At least we don't do a catch-all, anyone who we later find to be unlocatable. I don't think that would be enforceable, and I don't think that's something that's the right way to do it. But it's funny you should ask. Part of the reason I was late coming back in here, as I was pulling in this morning, about 8:55, I got a call from XCL, one of the, despite the 20 months since the election letters went out, one of the unlocatable owners who has been completely non-responsive throughout that 20 months, reached out this morning and said he was interested in leasing. And although the lease is not in hand, and that was the conversation out there, they are 99.9% sure that he is going to lease. So there will be a clarification coming shortly about that. But the long and the short of it is, the point of forced pooling is to address people who haven't had an opportunity to consent, and that's really the issue. So from my perspective as counsel, and from XCL's perspective, at least in the time I've worked with them, the point is trying to notify people about these operations so they can make their decisions. And if people come forward during the process, I think you could take a really, kind of down the line approach and say, you had 30 days, you didn't elect. But I don't think that's recognized the purpose of this. The purpose of this is to try and make sure that these interests are brought together for collective development, not to catch someone on 30 days. So there's a lot of working with people as they come forward during the process to see.
So if someone appears after this hearing, they will be afforded the opportunity to participate, or you'd have to come back and force pool that one entity?
Well, so, for example, in the 3536 unit, there's two non-consenting parties, Wesley Galloway Kent and Thomas and Jet Gray as joint tenants. Both of those parties will be pooled, assuming approval by the board here today, into all of these wells on these terms. If one of them comes forward 6 months from now and says, I'd like to lease, that opportunity is foreclosed. Now, it's my understanding the operator could always say, okay, we'll let you out of the forced pooling order. We won't impose that. We'll do this instead. The problem is there's a JOA that's being imposed in conjunction, and that JOA is really a contractual relationship between all of the consenting parties, in a sense, to the unit. And so it's my understanding, without being a JOA expert per se, that there are and can be some real concerns with who's entitled to share in the proceeds of that forced pooled lease. And if XCL takes a lease from someone, but 5 participating consenting owners have all agreed to share the costs as consenting owners, the JOA can say that all 5 of them share in the pooled interest. And so they may object to XCL saying, well, we're all 5 going to share this, but 3 months later, I'm going to take a lease from them and I'll keep it. And so after the forced pooling is entered, there really isn't, absent an amendment, in my estimation, there aren't going to be parties kind of reshuffled into leased and unleased in these wells, in these units. Obviously, the caveat is they can do that given the circumstances, especially if the JOA partners are supportive.
Thank you.
Yeah.
Any other questions or comments on the part of the board? Mr.
So those being force pooled in general in these 4 requests, are they mostly unlocatables, or are there some that just won't sign a lease that they know about?
It's kind of a mixed bag. For example, I'm not intimately involved in the well proposal packet process when they go out. That's well before I get involved typically. But it's my understanding that, some of these folks they've communicated with in the past about numerous other wells and numerous other developments, and no matter how many things they send them about this, they don't respond. One example, a pretty good example, I think, from these requests is Charles Wiggins. He's identified as being a non-consenting party and force pooled in the 132 08. Let me make sure I'm right here before I confuse everyone on the record. In the 13207, 13211, and 13212 matters, Charles Wiggins is identified as a non-consenting party. But when he received the well proposal packets, Mr. Wiggins elected not to participate. He elected to go non-consent and kind of signed parts of the JOA, but didn't sign all of it and didn't have it notarized. And despite being able to reach him the first time with the well proposal packet and sending him countless correspondences sent then, can't get him to respond and formally execute the JOA. And so he's included simply for imposition of the JOA on him. So I don't know if that helps address, but some parties are clearly unlocatable. They don't have addresses of record, or they've been gone for years. In my estimation, it's usually a combination of poor records in the county grandpa dies and the kids don't think to update addresses of record in the county records, something like that. But I don't have an exact answer. I would say the vast majority of these, as I understand it, are non-consenting, not unlocatable, if that helps.
Yep, thank you.
Just one more question. I understand that what you said earlier, that somebody is coming in rather late and they don't have a signed agreement as yet. If we issue this order today and you don't get that signed, I assume he would just be force pooled.
Well, so everyone's at a disadvantage, and I apologize for this. It was not my plan. Wesley Galloway Kent, we just discussed, is one of the 2 non-consenting parties in the 13208 matter, the 3536 unit, as I call it. Mr. Galloway Kent reached out this morning and would like to lease. The lease is not in hand. My conversation with my client, without divulging attorney-client privilege, the essence was, I have to have a decision when I walk back in the room. Whether you have 100% certainty or not, I need to tell the board. Because if we leave him in and he's pooled, you may have concerns with JOA partners going down the road, and I don't have time in the next minute to definitively tell you whether that's the case or not. If I remove him, you may be stuck with drilling his interest for free or having to come back in and modify this order to pool him a second time. The answer I got from them, given their relative level of confidence and their desire not to impose undue burden on anyone here, was, let's consider him leased. So part of what I was coming back in to discuss after the questions was a request by XCL to remove Wesley Galloway Kent as one of the non-consenting parties from those 3 matters. And I'll go through and identify that as we get to the approval portion, or the motion to approve portion of the request.
By following this path, is there any exposure to the board?
In what respect?
Well, if this doesn't work out for them and we go ahead and include him, not include him in the forced pooling, but later he can't come to some sort of agreement with them, is there any way for him to come back and say, hey, I've been forced pooled, but I wasn't, I was in the process. Does he have any legal?
Mr. Hanson, if I understand Mitch's testimony, or what he's about ready to do, is XCL is going to take the position that we're not exposed because they're going to remove him from the forced pooling order if in fact he doesn't comply with what XCL wants him to do, then Mitch will have to come back in here. But at least he's going to be afforded the opportunity at the 11th hour. So our exposure's now removed.
Yeah.
Okay.
Maybe more directly, the only exposure you would be exposed to is XCL coming back and saying, why didn't you pool him? But you're not pooling him because we're voluntarily requesting he be removed, so.
Okay.
And board, any other questions, comments? In that case, I do have a couple of comments and a couple of organizational, logistical things for how we proceed. First, I do want to restate again, I know I may sound like a broken record, this streamlined process, which is a bit novel for us with the submission of affidavits of experts and things, is useful, and today with such a heavy docket load, I think an absolutely necessary tool. However, we would want this to be the exception rather than the rule for how we proceed going forward. You know, a full-blown normal hearing would still probably be preferable when the docket load allows, and use of a hearing examiner is still probably a very preferred option to this process, just because I think it provides a more rigorous process in the long run. So I just want to reiterate that again. Secondly, I think we are going to want to vote on each docket item separately. So you're going to have to, we'd ask you to present exactly what relief is being requested for that docket item number. And then we'll go through the process on each one separately. Is that okay?
I'm happy to do that. That makes perfect sense. Can I have one moment to confer with the Division Counsel, just clarifying a question Ms. Garrison asked on the record so we can make sure we present the full evidence here?
Yes, please, but share with us what you decide.
We absolutely will. Off the record, 1 minute.
Chairman Borden,
Yes.
could I ask just a clarifying question of Ms. Garrison?
Yes, please proceed.
Ms. Garrison, with your question, were you trying to ascertain how much XCL owns or has leased and what's remaining?
No, I just want to know, we've got a weighted average of 18%. The non-consent represents 0.5% of the unit.
Okay.
That's all I want to know.
Okay.
Chairman, thank you. Quickly, Ms. Garrison, in response to the question you referenced, I just wanted to, on Mr. Gruel's urging, which I appreciate, mention on the record those percentages that you were interested in as part of the discussion. What I'll do is I'll do that as part of moving for approval of each one, if that's okay.
That'll be fine.
Thank you.
That sounds reasonable. Our division comfortable with that approach?
Absolutely.
Okay, please proceed, Mr. Mayo.
I guess it's that point in this messy hearing where I am excited to say I hereby would request that the board approve the request for agency action on file in docket number 2023-001, cause number 132-07. The specific request is to compulsory pool the non-consenting parties as identified in the request for agency action on page 3 for the estates and exhibit 2. For the cause 132-07, in response to Ms. Garrison's earlier question, that unit has approximately 3% of the unit that is unleased or has elected not to participate, or not elected to participate. Excuse me.
Division, are you comfortable with the relief requested as just stated?
Yes.
Board, any concerns? In that case, I would entertain a motion.
One clarifying point, is this the one where we have a non-consent into consent?
Thank you. Yes, all of them do, so I appreciate that. Matter 132-07. Parties being pooled are the parties identified in the request for agency action on file, Exhibit 2 and Paragraph 3. However, removed from those lists would be Emily Lazama as trustee of the Noble Family Trust, which was withdrawn by XCL at this hearing, and the estate of Oscar Nelson, which was also withdrawn at the record from this hearing. With respect to the 132-07 order, that constitutes the parties who are being pooled here today. And counsel and I will make sure the correct parties, as testified about, are included in the order.
Thank you, Ms. Sierra. That's appreciated. Any other questions or comments? I see there is one from Mr. Hanson. No? Okay. In that case, could we now entertain a motion?
I move for the approval for the request for agency in docket number 2023-001, cause number 132-07, as presented and stated.
I'll second that.
Any last comments from the board? Seeing none, all those in favor say aye.
Aye.
Aye. Let the record show that was unanimous.
Thank you.
Mr. Mayo, could you please prepare the necessary documents?
I'm happy to prepare the necessary orders for all these, happily. Thank you.
Thank you.
With respect to cause number 132-08, docket number 2023-002, cause 132-08. Again, the parties being pooled in that are as identified in the request for agency action and on Exhibit 2 and page 3 of that. Although during testimony a few moments ago, I stated that there were no changes to those lists of parties. During deliberations, as the board knows, I've since informed you that Wesley Galloway Kent is being removed from that list. So the only parties that will be subject to pooling in the 3536 order are Thomas and Jet Gray, husband and wife, and those estates and unknown parties identified under that. Ms. Garrison, with respect to your question earlier, it's about 0.7% of the unit that's non-consenting.
That number, those numbers you're just giving now, are they in the right?
They are. They're in, and I looked, each interest owners, and these are approximates because even today there's been a party removed, so I could be off by a significant number depending on factoring in Wesley's, Mr. Kent's interest. However, Miss Kent, I had no idea. I apologize. I assumed that. But I just look, they are in the declarations. The declaration of Kevin Anderson goes through and identifies each party being pooled and their percent ownership. Mr. Gravy goes through and identifies the collective percent of ownership and how that impacts the well costs. So
Division, are you comfortable with the request for relief as stated?
Yes.
Board members, any follow-up comments or questions? I would then entertain a motion.
I move that we approve the request for agency action in docket number 2023-002, cause number 132-08, as presented and stated.
I'll second.
Any last comments from the board? Seeing none, all those in favor say aye. Aye. Let the record show that was unanimous. Please complete the
Happily.
necessary documents.
Will do. Now, with respect to, those are the two 1280 units that have now been out of the way. The last two matters to discuss. The first, I'd like to, I guess, move for approval or request approval formally of XEL's request in docket 2023-08, cause number 132-12. Excuse me. Give me a minute. I'd like to, this is a novel procedure for all of us. Moving on to cause, docket number 2023-007, cause number 132-11. XEL would like to request that the board approve the requests on file as testified to here today. The parties being pooled in that matter, in the 132-11 matter, are as identified in the request for agency action, Exhibit 2 and Paragraph 3, with the exception of the removal of the Noble Family Trust and the estate of Oscar Nelson, as discussed earlier in Cause 132-07. Ms. Garrison, in response to your question, about 1.5% of this unit is non-consenting.
Division, are you comfortable with the requested relief as stated?
Yes.
Board, any last questions or concerns? In that case, I'll entertain a motion.
I move that we approve the request for agency action in the matter docket number 2023-007, cause number 132-11, as presented and stated.
I'll second the motion.
Any last comments from the board? Seeing none, all those in favor say aye. Aye. Let the record show that was unanimous. Please prepare the necessary documents, Mr. Mayo. I'm getting a strange sense of deja vu.
Well, hold on. There's more. With respect to the final cause brought by XEL today, docket number 2023-008, cause number 132-12. I'd like to request approval of the request as pleaded and testified to. The parties being pooled in that are as identified in the request for agency action, Exhibit 3 and Paragraph, Exhibit 2 and Paragraph 3, page 3. However, there are a couple of adjustments to this. This unit, this forced pooling covers sections, it's a 2560 that covers sections 25 and 26 and sections 35 and 36. So the parties removed from both of them will be removed from this one. The parties removed from this will be the Noble Family Trust again, which was withdrawn at this hearing, Oscar Nelson Estate, also withdrawn at this hearing by XEL, and finally at the 11th hour and 11th minute, Mr. Wesley Galloway Kent will also be removed from this, withdrawn by XEL. With those three changes, the parties identified in the request for agency action on file are the parties being pooled. They represent, Ms. Garrison, approximately 1.8% of this unit.
Division, are you comfortable with the requested relief as stated?
Yes.
Board, any concerns or questions before we? In that case, I will entertain a motion.
I'll move. Beat you. I'll move that we approve docket number 2023-008, cause number 132-12, as presented.
I'll second.
Any last comments from the board? Seeing none, all those in favor say aye.
Aye.
Aye. Let the record show that was unanimous. Please
No, this
complete the
time,
necessary
this time I
documents.
will not do it. No, I'm happy to. And I really appreciate the board's time and efforts. I know this was confusing for all, and it really, I think, was a better approach for these hearings, so thank you for that.
Thank you. Okay, now we're doing some, right? Yes. That's what I got. It's seven. It's the spacing order one. It's the reduction. It's setbacks.
Correct.
Okay, we are now moving on to the previous item number 7, which is now item number 5, which is docket number 2023-005, cause number 130-16, in the matter of the request for agency action of OVINTIV USA, Inc., for an order modifying the board's order entered in cause number 139-134 and 139-140 by extending the board's order entered in cause number 600-03 to reduce the north-south drilling unit boundary setbacks from 330 to 100 feet for the drilling units comprised in sections 25 and 36, Township 2 South, Range 2 West. Sections 6 and 7, Township 3 South, Range 1 West, and sections 13 and 24, and sections 14 and 23, respectively, Townships 3 South, Range 2 West. I will now call for my notes, which is appearances of counsel. Thank you.
Fred McDonald of Counsel Lear and Lear on behalf of petitioner OVINTIV USA, Inc.
Elizabeth Harris on behalf of the Division of Oil, Gas, and Mining.
To you, Mr. McDonald.
Thank you, Mr. Chairman. With me today, appearing virtually, which we again thank the board for that courtesy, are Mr. Jordan Lear, the senior land negotiator. Jordan, thank you. Mr. Sam McManus, who's the senior development geologist for the Uinta Basin, and Mr. Kendall Brown, who's the manager of the Uinta Reservoir Engineering. I would ask that the witnesses be sworn in at this time.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, if all of you guys can speak closer to the mic so that it comes through here.
I do.
Okay, thank you. Mr. Chairman, the resumes of all three witnesses were submitted collectively as Exhibit A in this cause. If separately asked, each would verify the contents of their resumes are true and correct. Mr. Lear will be a fact witness only. Mr. Brown has been previously recognized as an expert in both petroleum and reservoir engineering by the board. Presuming the division has no objection, we ask that he once again be recognized as an expert in reservoir engineering for purposes of this cause.
Division?
No objections. We'll stipulate to him being entered as an expert witness.
Board? Okay. Yes, we agree. He is an expert witness.
All right, thank you. And then Mr. McManus will be appearing for the first time in front of the board, so I will qualify him at the commencement of his testimony as an expert in geology. I also want to confirm, as our normal practice would be, that I will move for admission of all of our exhibits at the end of our presentation of Chief.
Thank you. That's appropriate.
Thank you. Members of the board, today OVINTIV is before you seeking modification of the board's orders entered in cause number 139-134 and 139-140 by extending the board's order entered in cause number 603 to reduce the north-south, being the heel-toe setback, for horizontal wells in 4 drilling units within OVINTIV's Central Basin area. True and correct copies of the 139-134, 139-140, and 603 orders were collectively submitted as Exhibit B. The testimony and exhibits you'll receive today will be similar to those the board received into evidence at the December 7th hearing in cause number 130-14, albeit with the technical data more specifically relating to the 4 drilling units at issue in this cause. As the board is aware, and as is evidenced by the 603 order, the data derived from drilling horizontal wells throughout the Uinta Basin is reflecting reduction of the heel-toe setbacks from 330 feet to 100 feet not only results in additional resource recovery that would otherwise be left in the ground, but also does not adversely impact the correlative rights of the production interest owners in the adjacent lands for at least 10 years, and even then only minimally. The testimony and exhibits submitted today will will confirm the same as to the 4 drilling units at issue. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5 subparagraph 3B and 40-6-6. Notice was sent via regular mail to all working interest owners, including unleased owners, in established drilling units, or if unspaced, the quarter sections adjacent to the affected area, and to the Bureau of Indian Affairs, the Bureau of Land Management being the government agencies having oil and gas jurisdiction over many of the lands. The mailings were sent to those parties at their last addresses disclosed by the relevant federal agency and Duchesne County Realty records. The record will also reflect that notice was also duly published in the Salt Lake Tribune on January 1st, 2023, the Uinta Basin Standard on January 4th, 2023, and the Deseret News on January 6th, 2023. The division elected not to file a response in this cause, and no other objections or responses were received. With that, I'll commence my examination of Mr. Lear. Mr. Lear, would you please state your name and business address for the record?
Sure. My name is Jordan Lair, and the business address here is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
Jordan, could you move just the mic a little bit closer to you?
Is that better?
Yes, much better. Would you state your position with OVINTIV?
Sure. I'm the senior land negotiator responsible for these units.
And you have access to the land records pertaining to these units, is that correct?
That's correct.
All right. Would you please state for the record OVINTIV's bonding and corporate status?
Sure. OVINTIV is a Delaware corporation in good standing with its principal place of business for the Rockies operations in the Woodlands, Texas. It's duly authorized to conduct business in Utah and is fully bonded with all appropriate federal, Indian, and state agencies. It is the successor by name change to Newfield Production Company and by merger of OVINTIV Production Incorporated.
Mr. Lear, I'm now going to show you what have been marked as Exhibits C through F for purposes of this hearing. They're shown on the PowerPoint. Do you recognize these exhibits?
I do.
Were they prepared by you or OVINTIV personnel with your review and input?
Yes, they were.
Turning your attention to what has been marked as Exhibit C, would you please explain to the board what this shows?
Sure. Exhibit C is what we refer to as the regional locator plat. It's showing the 4 DSUs at issue in red and their approximate location, all being just north of Mighton Town Site and straddling US 40 as it heads north towards Roosevelt.
Turning your attention to what has been marked as Exhibit D, please explain to the board what this shows.
Sure. So Exhibit D is the plat of the 4 DSUs at issue, showing the wells within them. For all 4 of these DSUs, OVINTIV is the majority working interest owner in each DSU and is therefore the operator of each. Currently, there are 2 long lateral horizontals already drilled, one under the 139-134 order and one under the 139-140 order. The one under the 139-140 order is the Tomlin Ute 7-1 2-2-36-25-1H. That's in sections 25 and 36 of 2 South, 2 West. And the other being the Bruce Ute 2-14 3-2-14-23-1H well, which is within sections 14 and 23 of 3 South, 2 West.
Turning your attention now to what has been marked as Exhibit E, please explain to the board what this shows.
So Exhibit E is the status of spacing around the subject DSUs. The blue crossed hatch are the lands that are subject to the 139-134 order, all of which are operated by OVINTIV. There's no overlapping units for vertical, directionally drilled, or short lateral horizontal wells. All convert to 2 sectional DSUs upon first long lateral horizontal well being drilled. And the conversion of sections 14 and 23 has occurred on April 1st, 2019 by virtue of the aforementioned Bruce Ute 1H well. The yellow hatched lands are the lands subject to the 139-140 order. Most of those lands are operated by XCL, but the DSU at issue is operated by OVINTIV. The 139-140 order provides for overlapping DSUs, and in this instance, OVINTIV owns the majority working interest in both the 2 sectional DSUs and in each sectional DSU. Moving forward, the gold hatched area are the lands subject to the 600-03 order. Those are also operated by OVINTIV. There are no overlapping units for vertical, directionally drilled, or short lateral horizontal wells, but this area already has the requested 100-foot north-south setback. All convert to 2 sectional DSUs upon first long lateral horizontal wells being drilled. And finally, the purple hatched lands are subject to the 130-09 order, also operated by OVINTIV. No overlapping units for vertical, directionally drilled, or short lateral horizontal wells within 100 feet north-south setbacks. All convert to 2 sectional DSUs upon first long lateral horizontal well being drilled. So all of the lands provide for conversion except for the yellow hatched is what we're getting at there.
All right, now turning your attention to Exhibit F. Please explain to the board what this shows.
Exhibit F is the notice area around the 4 DSUs that shows the red shaded areas show the working interest, or show the areas for where notice was provided to the working interest owners, including unleased owners in the established drilling units and adjacent unspaced quarter sections adjacent to the DSUs at issue.
All right, now I'm going to ask you to direct your attention to the original and supplemental certificates of mailing that were prepared by my office and that are on file in this cause. Do you have those in front of you?
I do.
All right. Do you recognize the names and the parties that are listed on that on those certificates?
Yes, I do.
And who are they?
The names of the parties and addresses are the working interest owners in the areas that we're showing in the red shaded areas, along with any of the unleased mineral owners.
All right, and how are those names and addresses compiled?
Those were compiled from internal land records of OVINTIV, including title opinions and a search of the BIA and Duchesne County records prior to filing the RAA by our broker, Lone Wolf Energy Incorporated.
All right, Mr. Chairman and members of the board, this was mailed out. The certificates show the mailing of the request for agency action by regular mail rather than certified mail with an Exhibit Z because of the amount of parties that were involved with that. With that, that concludes my examination of Mr. Lear.
Division, do you have any questions for this witness?
We have no questions for this witness. Thank you.
Board, any questions for this witness? Seeing none, back to you, Mr. McDonald.
Thank you. With that, I'll commence my examination of Mr. McManus. Mr. McManus, would you please state your name and business address for the record?
Samuel McManus, 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your current position with OVINTIV?
I am a senior development geologist with OVINTIV.
All right. Since this is your first time testifying in front of the board, would you please outline your education, work experience, particularly any experience in the Uinta Basin or analogous basins, any certifications or publications, and also any, if you've been recognized by any other oil and gas conservation commission?
Yes, absolutely. I'll start with I have a master's degree in geology from the Colorado School of Mines. I've been in industry working horizontal development programs across the United States for the past 17 years. I've been in this role working the Uinta Basin for the past just under 2 years, just short of 2 years. And I've testified before with the Oklahoma Corporation Commission for projects in that state.
Mr. Chairman, with that testimony and Mr. McManus's resume that was submitted as part of Exhibit A, we would ask that he be recognized as an expert in geology for purposes of this cause.
Division?
Division has no objection.
Board, any concerns? Seeing none, we recognize him as an expert witness.
Thank you. Mr. McManus, I'm going to show you what has been marked as Exhibit G for purposes of this cause. Was this prepared by you or OVINTIV personnel with your input and review?
Yes.
All right. Would you please explain to the board what it shows?
So this is a map and a rose diagram, and it's reflecting the wells in and around the subject area with the observed stress indicators from formation microimaging logs. And it's indicating that the average fracture orientation in the area is north 69 degrees west. So that's indicated both in the rose diagram and in the lines on the map, and also by the individual data points with the arrows on the map. That's kind of the first part, and then the second part on the map. Fred, let me know if I'm jumping ahead here, but we've got a star on the map which indicates our offset well with the measured fluid properties that will be talked about in the next part. But really the key message here on this exhibit is that the geologic characteristics of the 4 DSUs at issue are very similar in nature to the land subject to the 600-03 order and justify reduction of the heel toe setbacks by extension of that order from a geologic standpoint.
And that's your expert opinion on as far as relating to this cause. That's correct?
Yes, it is.
All right, thank you. Mr. Chairman, that concludes my examination of Mr. McManus.
Board, any questions for this witness?
No questions. Thank you.
Board. I'm already fatigued, I guess. Division. Board, any questions for this witness? Yes, Mr. Moon.
So my question's not particularly for this witness, it's for Fred, you, or anyone there. Why just these 4 DSUs? Why not make this request for reduced setbacks to include all the neighboring DSUs, more expansive? That's my question. I understand as you go further to the west, the stress orientation changes to more of a 45 degree, but in this area where it's as it is, why not more DSUs being requested here?
Mr. Brown, are you probably the best to answer that, or Mr. Lear?
I'll address Mr. Moon's question just from a land standpoint, I'd say the request here just being limited to these 4 DSUs is somewhat reflective of the notice requirements and the time frame for which we'd like to get the reduced setbacks. So I wouldn't say that this is all that we would potentially want to request similar setbacks for that apply to the 139, 134 order. It's just this is one of maybe subsequent ones to come, if that makes sense.
So it's more of a logistic and business situation with your timing of your wells and also the amount of land work that has to be done out in the county for notice purposes.
Correct.
Okay.
Thank you.
Any other questions from the board? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. I'll commence my examination. Mr. Brown. Mr. Brown, would you please state your name and business address for the record?
Yes, my name is Kendall Brown, and I work at 4 Waterway Square Place, Woodlands, Texas, 77380.
And what's your current position with OVINTIV?
I'm currently the Reservoir Engineering Manager for OVINTIV with responsibilities exclusively over the Uinta area.
All right, I'm going to turn your attention to what have been marked as Exhibits H through J for purposes of this cause. Do you recognize these exhibits?
Yes, I do.
Were they prepared by you or OVINTIV personnel with your input and review?
They were.
Turning your attention to Exhibit H, would you please explain to the board what this reflects?
So Exhibit H displays, with the prior testimony of the stress orientation we expect in these subject units, the fracture, effective fracture half lengths, as well as expected drainage radiuses. They are kind of shown in the green hash at the 5-year window post drilling and completions. This is a cartoon animation here, so it's not 100% to scale. So we're just showing the fracture tips at both ends of the well bores there, more or less indicating that we expect very little to no drainage after a 5-year window after these wells commence production.
Okay, turning your attention now to Exhibit I, would you please explain what this reflects?
Exhibit I is the data behind those drainage calculations. We utilize our best estimates of reservoir fluid properties as well as reservoir rock mechanics to determine the drainage calculations here. This is derived from a Hales and Evers correlation. It's a fairly industry known correlation, and in the table describes the most important variable here is the column labeled B, which is the drainage that's perpendicular to the fracture half length, and that is the key variable that we're looking for to determine the drainage and protect correlative rights of the adjacent lands. As you can see at that 5-year mark I spoke to, we're showing that would be about 77 feet. We push that forward to a 10-year frame. You're about at 108 feet, so very minimal impact at a 10-year time frame and really none at a 5-year time frame.
And this data was derived from the well that was shown on Exhibit G, is that correct?
The PVT data was derived from the offsetting unit that had the star that Mr. McManus spoke to. Specifically from that, we're pulling the viscosity component specifically from that data.
All right, thank you for that clarification. Turn your attention now to Exhibit J. Please explain to the board what this reflects.
Exhibit J is describing the economic benefit to all parties within the unit, both the working interest owners, the royalty owners, as well as the state from a tax standpoint. By reducing the setbacks, we're able to add an increased amount of lateral length that we're able to complete to each of these wells, which directly translates into an increased recovery that you can see in the variance table here. This increases the lateral length we're able to complete by about 4.6%, which directly relates to a 4.6% increase to the recoverable oil and associated gas and NGLs, as well as royalty revenue and severance tax revenue to the state. This does not translate to well costs increasing by that much. solely due to the fact that all surface-related facilities and drilling of the surface hole remains the same, whether we have this added lateral length or not. So it's a large benefit economically to all parties involved.
All right, is it then your expert opinion that reduction of the north-south drilling unit boundary setback is necessary to recover additional resource that would otherwise be left in the ground?
It is.
And is it also your expert opinion that the reduced setback should not result in material adverse drainage or waste and be protective of correlative rights?
That's correct.
Mr. Chairman, that concludes my examination of Mr. Brown.
Division, any questions for this witness?
With your permission, the division would like to ask that you recognize Ellis Peterson. He is a petroleum engineer with the division, and let him ask questions of the witness.
So recognized.
I do have a question for Mr. Brown. On your Exhibit I,
Yes.
there we go. You mentioned the well with a star where you got your PVT information, which would be the source for your viscosity and I assume total compressibility that went into your calculations. Could you please briefly describe your source for your permeability and your porosity values that went into these drainage calculations?
Sure thing. On the permeability, we've derived permeability primarily from history matching actual well performance. We feel that the permeability stated here allows us to best history match the actual performance we've got out of other nearby adjacent wells. And that's done through a simulation and rate transient analysis process. For porosity, that's primarily derived from offsetting well logs.
Okay, very good. You kind of answered my second question already, and that was to confirm that these same reservoir parameters are also supported by the performance of the wells, and where you've modeled the production using those, we know that these numbers weren't derived just to make a short drainage and actually will result in the kind of production you're seeing from these wells. Is that a correct conclusion?
Yes, these properties do accurately describe wells in the immediate area.
Okay, very good. I don't have any other questions. Thanks.
And no further questions. Thank you.
Board, any questions on this for this witness? Yes. Mr. Church.
Mr. Brown, what is the normal life that you anticipate for these wells? You've given us 5-year, 10-year drainage radiuses. How far beyond 10 years do you expect the well to produce?
That's a good question. The well lives will generally be in the 30 to 50 year time frame. The piece that's most important to understand, though, is that after this 10-year time frame, the production rates are so low out of these wells that there's really marginal recovery that occurs after that kind of 10-year time period. The wells can continue to produce after that, but they're very, very low rates at that point in time after primary production has declined off.
Thank you.
Mr. Moon.
So looking at the 110-foot fracture half length just raises lots of questions in my mind. So have you given some thought to reducing the east-west setback? Because what you're going to have now is anything within that 560 plus another 560 from the next section will be a 2560 drilling unit, correct?
Yeah. Sorry, can you say that one more time?
Yeah, so if your fracture half lengths are just 110, and granted you're going to have drainage, over time, more and more drainage, but that I guess my question is, have you given any thought to reducing the east-west setbacks also, so that you don't have, really, you're at 560 plus 560, 1,100 feet of area that's going to be in a 25 60 or 80 drilling unit. Anyways, 560 the appropriate number for the east-west setback?
That's a good question, and I think there's differing thoughts between some operators on how this has been approached and how we think the best way to solve that exact issue you're talking about. Our longer term goals, it's not a part of this exhibit, is to create the 2560 to be able to capture the resource you're speaking to. That's not a part of our request for agency action today, but in the longer term development plans of OVINTIV of the Uinta Basin, that is the plan.
Okay. Yeah, because just, you know, the same question goes to, you know, how many wells do you put in one horizon? You know, granted, you're only reaching out 110 plus some feet, just spacing those wells. Now, that's up to you guys. You're the professionals, but it seems like you can put a lot more wells than 4 or 5 in a drilling unit, you know, in one zone. And just how you space those is a big deal. So.
I definitely agree with you. That's an important part of our job.
Thank you.
Any other questions, board? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. That concludes our presentation in chief. At this time, I would move for admission of exhibits A through J inclusive.
They are admitted, exhibits A through J.
Any objection from the division?
Oh,
No
sorry.
objection. No.
Thank you, division. Perhaps I should ask if there's any concerns from the board on these exhibits as well. No, they are admitted.
Thank you, Mr. Chairman. With that, I'll just reserve my closing comments after the division's presentation.
Division, over to you.
Just in general, the division reviewed this request thoroughly. We did a thorough analysis of the calculations. We replicated the drainage calculations and came to similar results. The results were consistent. It appears that there would be very little drainage beyond those setbacks, and so the division is supportive of granting this request.
Excellent. Mr. McDonald, do you have any?
No, other than,
concerns, questions?
again, you know, this is consistent relief as the board has granted in other areas, in particular the 600-03 and the 130-09 areas. This is, again, I think the data is showing that reduced setbacks are going to be the trend. All the statutory and regulatory requirements for granting the requests have been met, and we would ask that the board grant the request as submitted. We also thank you for your time, and particularly the IT people for allowing the virtual appearance of the witnesses.
Thank you. Board, do you have any questions for the division? In that case, do we need to consult? Okay, let's adjourn and go off the record briefly, and we'll return as quickly as we can. We are back on the record, and I would entertain a motion.
I'll make a motion to grant the request for agency action on docket number 2023-005, cause number 130-16 as requested.
Go ahead.
I'll second the motion.
Any last comments from the board? Seeing none, all those in favor say aye. Aye. Mr. McDonald, could you please prepare the necessary documents?
Certainly, thank you.
Thank you. I would now like to propose that we break for lunch. It's just shy of 11:45. Why don't we reconvene at 12:45 for the next matter? And we are off the record. Welcome back. We are on the record. The next matter for this afternoon is docket number 2022-015, cause number 132-04, in the matter of the amended request for agency action of OVINTIV USA, Inc. for an order partially vacating the order entered in cause number 139-96, insofar as it pertains to Section 18, Township 3 South, Range 1 West, and instead pooling all interest, including the compulsory pooling of the interests of certain consenting and non-consenting owners in the 6 Amy series of wells in the drilling unit established for production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations. I'll now ask for appearance of counsel.
Fred McDonald of Counsel Lear and Lear on behalf of petitioner OVINTIV USA, Inc.
Trevor Gruel with the Utah Attorney General's Office on behalf of the division.
Over to you, Mr. McDonald.
Thank you, Mr. Chairman. With me for this matter are Mr. Peter Burns, who is a senior land negotiator, and again, Mr. Kendall Brown, who is the manager, Uinta Reservoir Engineering. Again, we appreciate the board's allowing them to appear virtually in this matter. I would ask that they be sworn in at this time.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Members of the board, the resumes of both witnesses were submitted collectively as Exhibit A. I have separately asked each would verify the contents of the resumes are true and correct. Both were previously recognized by the board and/or through its designated hearing examiner as experts in petroleum land management and petroleum engineering, respectively. Most recently in cause number 13206, heard in November of 2022, and which was a compulsory pooling matter, as is this one. Presuming the division has no objection, we again ask the board to recognize them as experts in those respective fields for purposes of today's proceeding only.
Division.
Yeah, the division has reviewed the resumes submitted by, on behalf of these individuals and has no objection with them being recognized as experts.
Board, any concerns? Seeing none, they are so recognized.
Thank you, Mr. Chairman. And also, again, I will be moving for admission of our exhibits at the end of our presentation in chief.
Perfect, thanks.
As the board is aware, the request for agency action in this cause was initially filed back in June of 2022. It has twice been continued to allow negotiations to continue between OVINTIV and Bro Energy LLC, which is a consenting but unpooled working interest owner, on a particular provision of OVINTIV's proposed joint operating agreement. As reflected in OVINTIV's amended request for agency action, the negotiations have failed to resolve those issues between those two parties. As only a courtesy to the board, the division, and their respective counsel, given the large number of matters on today's dockets and the attorneys and the division staff workloads, OVINTIV and Bro Energy agreed that the issues between them may be separately heard by the board at its February 22nd, 2023 hearing. As a consequence, today's hearing is focused on the compulsory pooling of certain non-consenting owners only in the 6 wells at issue. This procedure was memorialized in the board scheduling order entered last Thursday. The Amy wells are all located within the drilling unit established for lower Green River Wasatch production, comprised of the entirety of sections 18 and 19 of Township 3 South, 1 West in Duchesne County. The drilling unit was established by board order entered on July 21st, 2015 and cause number 139-134. A true and correct copy of the 139-134 order was submitted as part of Exhibit B. In accordance with the 139-134 order and the APDs approved by the division and the Bureau of Indian Affairs, OVINTIV drilled the 6 Amy wells as OVINTIV's second attempt at cube development, which is concurrent drilling and completion. Mr. Brown will address cube development and the associated risks in his testimony. The first Amy wells date of production was October 30th, 2021, resulting in the conversion of the Section 18 and 19 drilling unit effective as of November 1st, 2021, per the 139-134 order. Some of the fee leases were granted by parties claiming buy-through under the estates of certain deceased parties, as identified in the amended request for agency action, for whom no confirmatory Utah probate proceedings have been initiated, or if initiated, are incomplete as to proper distribution to the heirs or devisees. As such, there was the possibility of some unknown party claiming buy-through or under those estates who is unleased and not pooled. Consequently, as to such potential unknown heirs or successors, pursuant to the June 10th, 2022 ex parte order of the board, notice to such unknowns was published in the Uinta Basin Standard for 2 consecutive weeks. No party has responded to that notice or otherwise tendered his or her share of the cost of the wells. OVINTIV therefore seeks to have these unknown parties compulsory pooled and declared as non-consenting owners. Proof of the publication was to these unknown heirs or successors was submitted as Exhibit H in this cause. As to the non-consenting parties, OVINTIV seeks imposition of a 300% risk compensation award and the terms of a joint operating agreement materially the same as signed by another working interest owner in the drilling unit, and which terms have previously been deemed just and reasonable by the board in other compulsory pooling matters. During the recoupment period, the unleased non-consenting owners will be entitled to a 14.7643% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the date of the spud of the first of the Amy wells. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations found at R 649-2-8A and R 649-2-9A. Copies of the original request for agency action and the amended request for agency action were mailed regular mail to all production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records, to the Utah School and Institutional Trust Lands Administration due to state mineral ownership within the drilling unit, and to the Ute Tribe, Ute Distribution Corporation, and the Bureau of Indian Affairs and the Bureau of Land Management due to the tribal and allotted mineral ownership within the drilling unit. In addition to the published notice of opportunity to participate in the Uinta Basin Standard, which I previously mentioned, notice of the filing of the original request for agency action and the original scheduled hearing date was also published in the Deseret News on July 1st, 2022, in the Salt Lake Tribune on July 3rd, 2022, and the Uinta Basin Standard on July 6th, 2022. Republication due to the continuances is unnecessary per the board's regulations. The division has not filed any responsive pleading in this cause as relating to these non-consenting owners only. No other objections or responses to the original request for agency action or the amended request for agency action by the non-consenting owners was timely filed. Since none of them have timely filed a response or appeared today, pursuant to Utah Administrative Code Rule R 649-104-150 and R 641-108-400, we move to enter an order of default against them. And if you'd like to rule on that motion at this time, that would be fine.
Division, any concerns?
No objection from the division on the motion for a default.
Board, before we ask for a motion, any concerns?
Just one. Mr. McDonald, do you know what percentage of the unit is being pooled?
Yes, Mr. Burns will testify to that.
Thank you.
I will entertain a motion for the default.
So I would make that motion, but I want to understand what we're doing when what are we saying when we're ordering a default?
That they haven't appeared and that the request as to them is going to be approved, presuming we meet our burden of proof.
Okay. Okay. So moved.
I'll second the motion.
Any other comments? Seeing none, all those in favor say aye.
Aye.
Let the record show that was unanimous.
Thank you, Mr. Chairman. With that, I'll commence my examination of Mr. Burns. Mr. Burns, would you please state your name and business address for the record?
Yes. Peter Burns, and OVINTIV's address is 4 Waterway Square Place in the Woodlands, Texas, 77380.
All right, and what is your current position with OVINTIV?
I'm a senior land negotiator with responsibility over this drilling unit, among others, in the Uinta Basin.
Would you please state for the record OVINTIV's corporate and bonding status?
Yes. OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of OVINTIV Production, Inc.
Mr. Burns, I'm now going to direct your attention what have been marked as Exhibits C through F. They're shown on the PowerPoint. Do you recognize these?
Yes.
All right, and were they prepared by you or OVINTIV personnel with your review and input?
Yes, they were.
Turning your attention now to what has been marked as Exhibit C, please explain what this represents.
Exhibit C is a regional locator plat showing sections 18 and 19 of the subject unit located 1 mile northeast of the Mighton Town site and 1 mile east of US 40 in Duchesne County.
Now turning your attention to Exhibit D, please explain to the board what this shows.
Exhibit D is a plat of the oil and gas ownership in this DSU. It shows the 18 different oil and gas tracts. Tract 1 is the state tract. 97.5% of tracts 7 and 8, all of tracts 10, 11, 15, 16, and 18, and 99.074074% of tract 12, and 97.47942% of tracts 13 and 17 are Indian allotted tracts. And tract 14 is a tribal tract.
And I just again to remind the board that as provided in the statute, the royalty under those leases are not included in the calculation of the average weighted landowner's royalty applicable to the unleased non-consenting owners. Only the fee owners' lease royalties are accounted for. Please go ahead, Mr. Burns.
The remaining portions of tracts 7, 8, 12, 13, and 17, and all of the remaining tracts are owned in fee. As Mr. McDonald mentioned, several lessors claim title in various fee tracts through one or more of the estates of the following deceased record mineral interest owners: H.O. Hall, Chesley Walker Sr., Donald D. Glenn, Ruth Walker, and C. Fulmer Tebbs. Either no Utah probate of the estates have been initiated, or if filed, they are incomplete, and that there has been no proper distribution made to the heirs or devisees. Although based on affidavits of heirship and other inquiries and research done by OVINTIV's lease broker, we believe that we have leased all of their successors. However, without an order from a Utah court confirming their succession, the possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore OVINTIV seeks to compulsory pool their interests. OVINTIV has executed and recorded a pooling declaration, pooling its fee leases in the drilling unit pursuant to authorization contained in the pooling clauses of said leases, and we are in the process of filing a communitization agreement to communitize the Indian leases with the fee leases.
Okay, turning your attention now to Exhibit E, please explain to the board what this represents.
Yeah, Exhibit E is a plat of the Amy well locations, and this shows generally the locations of the wells within sections 18 and 19. All 6 of the Amy wells were spud in late May and early to mid-June 2021, and the first 2 were completed and began production on October 30th, 2021, with the others following in November of 2021, as outlined in the ARAA. These wells constituted one of OVINTIV's initial attempts at cube development, which Mr. Brown will address in more detail. Consequently, conversion of the existing wells to the sections 18 and 19 drilling unit occurred effective November 1st, 2021 per the 139-134 order.
Now turning your attention to Exhibit F, and this goes to Ms. Garrison's question. Please explain what this shows.
Exhibit F is a breakdown of the working interest ownership within this DSU. OVINTIV is clearly the majority working interest owner in and therefore operated of the drilling unit. Broughton Petroleum, Inc. is a non-operating working interest owner which signed a JOA naming OVINTIV as operator.
And the Bro Energy interest is the one that we're going to deal with next month. Is that correct?
Yes, that's correct.
So getting to Ms. Garrison's question then, there are no non-consenting owners that are known at this point. You believe they have them all leased, and the only reason that you're seeking compulsory pooling is in the event there's some other party out there that it hasn't leased or participating, correct?
That's correct. Yes, we believe we have leased everyone with an ownership in this unit.
Okay, referring to Exhibit H, which was the proof of publication submitted from the Uinta Basin Standard, were there any responses to that publication that OVINTIV received?
No.
Other than the Bro Energy response, is that correct?
Correct, yes.
All right. Now, turning your attention to Exhibit I, which we only have certain provisions up on here because it's a large document. Was this document prepared by you?
Yes.
All right. Would you please explain about the document itself?
Yeah, this is a JOA form for this unit. This is a form utilized as an industry standard form supplied by the American Association of Professional Landmen, Form 610. This is the 1989 version with modifications to address horizontal wells. The terms and conditions contained therein, including the modifications made, are consistent with the JOA executed by Broughton Petroleum in this particular drilling unit and are commonly found in more recently developed horizontal well drilling units. OVINTIV has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, Javelin, and other major Uinta Basin operators.
All right, turning your attention now to the PowerPoint, which is a highlighted portion. Do you see the portion that's highlighted in yellow?
Yes.
All right, would you please outline what that is?
Yes, this page 7 of the JOA outlines the non-consent penalty. In this case is a 100%, 300%, which is the same as contained in the JOAs signed by the other working interest owner in this drilling unit.
All right, now turning to the next page, do you see the highlighted portion on this as well?
Yes.
All right, would you please outline what that says?
This is Exhibit C of the JOA, which is the COPUS accounting procedure form. Again, this is standard industry form, almost universally utilized, similar to other JOAs in the Uinta Basin. Page C3, Article 3B sets the interest rate at the prime rate in the published in the Wall Street Journal, plus 3%. And this is fair compensation and to encourage timely payment of chargeable costs and expenses.
All right, turning to the next page again, do you see the highlighted portion?
Yes.
Okay, would you please outline what that shows?
Yes, this is page C9 of the Exhibit C, the COPUS accounting procedure. This outlines the overhead charges, which are $10,520 for the drilling rate and $1,052 for the producing rate.
All right, is it your expert opinion then that the terms and conditions of this proposed joint operating agreement to govern operations between a non-consenting party and OVINTIV are fair and reasonable and consistent with those accepted by other working interest owners in the drilling unit and those others accepted by industry and in particular the Uinta Basin with respect to horizontal operations?
Yes.
All right, and the Exhibit A to the joint operating agreement, will that be modified if and when any of these non-consenting parties or these unknown parties that are claiming by through those estates are determined?
Yes.
All right. Reminding the board again, Utah Code annotated section 40-6-6.5, subparagraph 6 and 8, provide a compulsory pooled unleased owner is entitled to payment of the average weighted fee landowner's royalty during the payout period. It does not include federal, state, or Indian lease royalty. Now, Mr. Burns, turning your attention to Exhibit K, would you please explain what this shows? Or first of all, was it prepared by you?
Yes.
All right. Please explain what it represents.
This spreadsheet reflects the calculation of the average weighted fee landowner's royalty for sections 18 and 19, the Amy drilling unit, as of the date of spud of the first Amy well. And in this calculation, the average weighted fee royalty is determined to be 14.7643%.
All right, now, Mr. Burns, I'm going to direct your attention to the certificate and supplemental certificates of mailing. These were pleadings prepared by my office and already on file in this cause. Do you have those in front of you?
Yes, I do.
All right, do you recognize those people that are listed there, and
Yes.
who are those people?
These are the people shown, all the production interest owners within Section 18 and 19. The addresses were derived from a title opinion effective as of January 14th, 2021, as updated by a search of the county records by Lone Wolf Energy, our lease broker in the basin, and OVINTIV's internal records.
And for the board's information, all of the mailings to those owners except Bro Energy and its lessor were given by regular mail, given the large number of parties. With that, that concludes my examination of Mr. Burns.
Division, do you have any questions for this witness?
No questions for this witness.
Board, any questions for this witness? Seeing none, back to you.
Thank you. I'll commence my examination of Mr. Brown. Mr. Brown, again, would you please state your name and business address for the record?
My name is Kendall Brown, and business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And again, your position with OVINTIV is?
I'm the reservoir engineering manager with responsibilities specifically to the Uinta Basin.
All right, Mr. Brown, directing your attention to exhibits M through O. Do you recognize these exhibits?
Yes, I do.
And were they prepared by you or OVINTIV personnel with your review and input?
Yes, they were.
All right, turning your attention to exhibit M, and this is a 6-page exhibit. Please explain to the board what this shows.
Each one of these pages is the specific capital and direct operating expenses that OVINTIV incurred in the drilling and completions and production of the 6 Amy wells that matter.
And what were they, is this current through October 31st, is that correct?
That is correct.
All right. And how do these actual costs compare with the estimated original AFE costs that OVINTIV had projected?
The costs for these wells were pretty in line with expectations. Due to some risk, there's a little variance there as expected, but very fair and reasonable within the expectations going into drilling these. Okay,
Again, so then in your expert opinion, you do consider these fair, reasonable, and necessary, and that the wells were deemed economically feasible, as that term is used in the 139, 134 order. Is that correct?
That's correct.
All right. Would you please address for the board, what are the estimated plugging and abandonment costs for these wells?
OVINTIV's estimated cost is $75,000 per well on a gross basis.
All right, now turning your attention to Exhibit N, would you please explain to the board what this shows?
Exhibit N is a aerial plat showing the Amy wells that matter, the 6 wells. It also shows wells around that drilling unit that were drilled at the time the Amy wells were put online. One thing to note on here, you can see a lot of wells in the area are Uteland Butte wells, denoted in green. The Amy was the second cube development that OVINTIV undertook, and what I mean by that is essentially a larger multi-pad development where we're stacking wells on top of each other. And what I mean by that is drilling multiple formations vertically on top of each other in order to capture the resource.
Now turning your attention to Exhibit O, would you please go through the points shown on this?
Yes, so the pre-spud risks identified to the Amy, the first one listed here, a little unique to this one as it is in fairly close proximity to a saltwater disposal well. We have seen in other basins that we operate in that can cause challenges with taking on increased pressures, which can inhibit mud properties, et cetera, if those injection zones are contributing to water into the formations. There also is offset vertical wells in the unit that were pre-existing prior to the horizontal development. The depletion of those vertical wells can impact reservoir pressures, which can lead to lost circulation. The other thing to consider, and this is not unique to this unit, this is true for every unit we drill in this basin, is all the formations, the Upper Castle Peak, the Uteland Butte, and the Wasatch, they each contain different levels of clay intervals while drilling, which can lead to hole instability, which can lead to either getting the drill bit stuck or the hole collapsing and us having to essentially re-drill that. The actual risks that we encountered while drilling these wells, the biggest one was out on the Amy 44H, which incurred significantly more drilling costs than the other wells. Was we did experience zone of low pressure while getting close to one of the vertical wells. We lost circulation while drilling in that, had to plug that zone off and re-drill it into a slightly shallower formation. And then on the Amy 3H was another one. We had some issues with some shallow freshwater flows while trying to set surface casing. Just kind of slowed down the whole process there a little bit on the Amy 3H.
All right, given these wells and your testimony, is it your expert opinion then that a 300% risk assessment award was justified for this drilling unit in these wells?
It is.
All right, thank you. That concludes my examination of Mr. Brown, Mr. Chairman.
Thank you. Division, any questions?
No, not at this time.
Board, any questions for this witness? Yes, Mr. Moon.
So on that Amy 444H, where you did have a low pressure, how close to the old vertical well were you when that happened? And it sounds like it was significant enough you had to actually sidetrack. How did you just describe that a little bit? I'm just curious.
Yeah, the exact distance I don't have in front of me at this time. I believe it was in the range of several hundred feet, but the exact distance, I don't have that in front of me. And you are correct. Was we'll call it a high porosity streak there that that vertical well apparently had depleted. We did lose circulation there. We set a cement plug, and when we re-drilled the lateral, we re-drilled it about 20, 30 feet shallower, and we're able to get in a little bit of a different rock there that wasn't depleted.
So you drilled clear down into the production zone, and you were going laterally when this happened. So that was a significant deal to have to re-drill. Do you have to re-drill the whole vertical section also?
Fortunately, we didn't have to re-drill the whole vertical section, but we did have to re-drill the horizontal section.
Okay.
Thus increasing the cost significantly of that well.
Okay.
Any other questions from the board? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. At this time, I would move for admission, and I'm going to go very slow on this because there's going to be some exhibits that we're going to deal with next month as opposed to this month. So I'm going to move for admissions of Exhibit A, the 139-134 order, which was part of Exhibit B, Exhibits C through F, Exhibit I, Exhibit K, and Exhibits M through O. And as I mentioned, the remaining exhibits will relate to Bro and its lessors and will be addressed at next month's hearing.
Thank you. That matched what I saw presented. Any concerns from the division with that?
No concerns.
Any concerns from the board with entering those? Okay, so Exhibit A, B, C, D, E, F, I, K, M, N, and O are so entered.
Thank you. With that, I'll reserve my closing remarks after the division's presentation.
Okay, over to the division.
Yeah, the division is supportive of granting the relief currently being requested. There is an outstanding issue with Bro, as discussed by counsel for OVINTIV, and that will be heard next month, which would complete this compulsory pooling matter. But as far as pooling the rest of the interests, which are only interests that could come about that are currently unknown, the division is supportive of pooling them.
Thank you. Yes, Mr. McDonald?
No, I just thank you. Again, it seems like every matter today is a little bit convoluted. But again, what we're dealing with here, and it's very important to distinguish that Bro Energy is a consenting owner, and that will be dealt with next month. We're only dealing with the non-consenting owners, and as to this one, there are contingent parties out there. OVINTIV believes it has everybody leased. But again, we've experienced a situation where without orders from the court, there could be other parties out there, and so we're doing that. With that, as to the non-consenting owners, we believe we've met all the statutory and regulatory requirements, and we would ask that the board compulsory pool and impose the risk assessment award on those non-consenting parties as requested in the amended request.
Thank you. Board, are there any other questions?
I have a question.
Yes.
So, Mr. McDonald, this 0.9%, you think you have it, you've talked to all these people, and so you want this order to apply not only to the people you know today, but people who might come out of some court proceedings?
There's a potential for that as well. Again, if you recall, the only reason that the publication is allowed is OVINTIV had to make a showing to the board that they exhausted and made good faith efforts to try and identify all these people. And they did as far as they knew. They inquired of parties. It's all in that affidavit that allowed the publication. So the publication is the proper notice to these unlocatables.
Okay.
And without a response from them, it's appropriate to compulsory pool them and declare them as non-consenting owners. But we've had situations where, despite all of that effort, a court order comes out and all of a sudden there's somebody that you had no idea was there. It would have been the stepbrother that somebody didn't like in the airship affidavit or something of that nature.
Thank you.
I believe we're just going to retire briefly for a consultation, and we'll be back as rapidly as we can.
Thank you.
Thank you. We're off the record. We are back on the record. Thank you for your patience. Before we rule on this specific matter before us today of this bifurcated matter, which is related to the non-consenting parties, I think the board just wants to encourage OVINTIV and BRO to come to an agreement on the outstanding JOA issues over the next month, if at all possible. I'm sure you realize that would be the preferred outcome for probably all parties in this room. So,
And not in this room.
yes, and not in this room. Thank you. So I would entertain a motion on the matter at hand here. Or do we need to restate what that is
So
for everybody?
I move that we would approve docket number 2022-15, cause number 132-04, request for agency action. I move that we approve that.
Mr. Moon, I would just state that that's as to the non-consenting owners only.
As to the non-consenting owners.
I'll second the motion.
Any last comments from the board? All right, seeing none, all those in favor say aye.
Aye.
Aye. Let the record show that was unanimous, and that concludes that item. If you will please prepare the necessary documents.
I will, Mr. Chairman.
Thank you. Which brings us to docket number 2023-06, cause number 132-10, in the matter of the request for agency action of OVINTIV USA, Inc. for an order pooling all interest, including the compulsory pooling of the interest of certain consenting and non-consenting owners in the Allen Ute 1623-4-2-24-13-7H well and the drilling unit established for the reduction of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of all of sections 13, 24, and 25, Township 4 South, Range 2 West. I'll now ask for appearance of counsel.
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner OVINTIV USA, Inc.
Trevor Gruelle with the Utah Attorney General's Office on behalf of the division.
Over to you, Mr. McDonald.
Thank you, Mr. Chairman. Again, with me today on this matter is Mr. Jordan Lear, the senior land negotiator, and Mr. Kendall Brown, the manager, Uinta Reservoir Engineering. I'd ask that they be sworn in at this time.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Chairman, the resumes, the resumes of both witnesses were submitted collectively as Exhibit A. If they were separately asked, each would verify the contents of the resumes are true and correct. Both were previously recognized by the boards and experts in petroleum land management and petroleum engineering, respectively. Most recently in cause number 13205 as to Mr. Lear, and the last matter as to Mr. Brown. Presuming the division has no objections, we ask that the board again recognize them as experts in those respective fields for purposes of today's proceedings only in this cause.
The division has no objections.
Board? Seeing no objections, they are admitted.
Thank you, Mr. Chairman. Also, I want to confirm that the board received the supplement to Exhibit Z filed on Monday. That's okay.
Yes,
thank you.
you.
And again, I will be making the moving for admission of the exhibits at the end of my proceeding and our presentation in chief. Again, this matter is similar to the one that you just heard in that this is a dispute between, involves a dispute between OVINTIV and International Petroleum Limited Liability Company, which is, has similar principles to Bro Energy. International Petroleum Limited Liability Company in this matter is also a consenting owner but not pooled, and they are disputing the same provision of OVINTIV's proposed joint operating agreement. Consequently, this cause, as a courtesy of the board, we're going to only address the non-consenting owners in this matter as well, so it's very similar to what we just talked about. In this particular case here, The Allen well is located within the drilling unit for Lower Green River Wasatch production, comprised of the entirety of sections 13, 24, and 25. Section 25 being a very small partial section due to the Uinta Basin, or Uinta Special Meridian line. This is all in Duchesne County. That drilling unit was established by the board's order on December 14th, 2021, in cause number 13009. A true and correct copy of the 13009 order was submitted as Exhibit B in this matter. In accordance with the 13009 order and the APDs approved by the Division and the Bureau of Indian Affairs, OVINTIV drilled the Allen well as a long lateral horizontal well in the west half of the drilling unit, with first production on May 16th, 2022, with producing intervals in the Uteland Butte Formation. There are 8 existing vertical directionally drilled wells within the drilling unit, production allocation from which converts to the wellbore base from a wellbore basis to the drilling unit basis effective as of June 1st, 2022, pursuant to the 13009 order. Only one of these wells has an owner in a non-consent status, but pursuant to the 13009 order, OVINTIV will waive further recoupment as of the date of conversion. As alleged in the request for agency action, Tren J. Grant is an unleased owner who was provided the requisite notice of opportunity to lease or participate, but never timely responded. Consequently, OVINTIV seeks to compulsory pool his interest and declare him as a non-consenting owner. And as is the previous matter, there are, again, some owners that are deceased that do not have estate closing orders or orders determining the heirs. OVINTIV believes they have leased all of those parties, but again, in the event that there are none out there, we're seeking to compulsory pool and declare them as non-consenting owners as well. Notice was published to them in the Uinta Basin Standard as per the board's December 13th, 2022 ex parte order. The proof of publication to those unknown heirs or successors was submitted as substitute Exhibit J in this matter. As to the non-consenting owners, OVINTIV seeks the imposition of a 300% risk compensation award in the terms of a joint operating agreement materially similar to the other working interest owners in the drilling unit, and which terms have been previously deemed just and reasonable by the board and other compulsory pooling hearings. During the recoupment period, the unleased non-consenting owners will be entitled to a 16.867232% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the date of the spud of the Allen well. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations R649-2-8A and R649-2-9A. Copies of the request for agency action were mailed certified mail return receipt requested to Mr. Grant and via regular mail to all the production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records. In addition to the published notice of opportunity to participate in the Uinta Basin Standard, notice of the filing of the request for agency action in this hearing was also duly published in the Salt Lake Tribune on January 1st, 2023, the Uinta Basin Standard on January 4th, 2023, and the Deseret News on January 6th, 2023. The division, again, has not filed any responsive pleadings in this cause as relating to these non-consenting owners. No objections excuse me, or responses to the requests from any of the non-consenting owners were timely filed. As none of these non-consenting parties filed a timely response pursuant to Utah Administrative Code R641-104-150 and R641-108-400, we again move to enter an order to default against them. And again, Mr. Chairman, if you want to rule on that motion now.
Yes. Any objections from the division?
No objections for the current motion.
Any concerns or need for discussion on part of the board? In that case, I would entertain a motion.
So moved.
Second. All those in favor say aye. 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 Let the record show that was unanimous.
Thank you, Mr. Chairman. With that, I'll commence my examination, Mr. Lear. Mr. Lear, again, would you please state your name and business address for the record?
Sure. My name is Jordan Lair, and the business address here is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And your current position with OVINTIV again?
I'm the senior land negotiator with responsibility over this drilling unit, among others, in the Uinta Basin.
And for purposes of this cause, would you again state for the record the corporate and bonding status of OVINTIV?
Sure. OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of OVINTIV Production Incorporated.
All right, Mr. Lair, I'm going to show you what have been marked as Exhibits C through E for purposes of this hearing. Do you recognize these exhibits?
I do.
Were they prepared by you or OVINTIV personnel with your review and input?
They were.
Turning to Exhibit C, would you please explain to the board what this represents?
Sure. Exhibit C is a locator plat, and it's showing in yellow the drilling unit, which is located approximately 3.5 miles due south of the town site of Mighton.
Now turning to Exhibit D, would you please explain the significance and what this exhibit shows?
Sure. Exhibit D is a plat of the well location and the ownership of the mineral tracts that comprise the DSU. It's showing the general location of the Allen well in the west half of the DSU, and the surface location is in the adjacent section 23. Pursuant to the 13009 order and an APD approved by division in the BIA, the Allen well was spud on March 1st, 2022, and completed as a producing oil well with productive intervals within the Ulan Butte member of the Space Lower Green River Wasatch Formation. The date of first production was May 16th, 2022. And although not reflected on this plat, there is one producing vertical well in section 13 and 7 producing vertical/directionally drilled wells in section 24, which were drilled under the general well siting rule, and consequently production allocation has been on a wellbore basis pursuant to the rule of capture. Pursuant to the 130-09 order, production allocation from those wells converted from a sectional basis to the DSU basis as of June 1st, 2022, being the date of the first month after first production from the Allen well. Of those wells, there is currently only one well with a pending non-consent recoupment. Specifically, Wilkin Oil Company is currently in non-consent status in the Wilkin 15-24-4-2 well located in the southwest quarter of the southeast quarter of section 24. Also pursuant to the 130-09 order, any further recoupment owed from Wilkin Oil Company in the Wilkin 15-24-4-2 well is waived as of the date of conversion. As the plat shows, there are 24 different mineral tracts, and tracts 3 and 15 are tribally owned. The remaining tracts are owned in fee privately.
Right. Now, at this point, I just want to again point out to the board that the tribal tracts are not included in the average weighted fee royalty calculation, which he will testify to later. Please proceed. Okay, now turning to Exhibit E, please explain to the board what this shows.
So Exhibit E is the DSU working interest ownership summary. In brief, it shows that OVINTIV is the majority lessee/working interest owner in the DSU and is the operator of the Allen well. The additional lessees and working interest owners in the DSU, excluding IP, are Ute Energy Exploration and Marketing LLC and Wilkin Oil Company. Both have signed JOAs with OVINTIV and the terms of which contractually govern well elections, including the elections made on the Allen well. OVINTIV has executed and recorded a pooling declaration, pooling its fee leases pursuant to the authorization contained in the various pooling clauses of the lease. And we're in the process of securing a communitization agreement communitizing the tribal lease with the fee leases.
All right, now I'm going to direct your attention to Exhibit F, which we do not have a PowerPoint for. Was this an official business record of OVINTIV?
It is.
All right, would you please explain to the board what it shows?
This is the notice of opportunity to lease or participate sent to Mr. Tren J. Grant for the Allen well, along with proof of delivery. Mr. Grant owns of record an unleased 50% oil and gas interest in Tract 24, which equates to a 0.073235% working interest in the DSU. There's Receipt was confirmed for the notice of opportunity by Mr. Grant on June 13th, 2022, and no further response was ever received.
All right, can you address the other non-consenting owners, identifying who the decedents are and that for the record?
Yes, so as Mr. McDonald mentioned at the start of this, there are several lessors claiming title in these lands through one or more estates of the following deceased record mineral interest owners: Edwin Miller, Callie Maxine Miller Stein, Jacqueline Winterrose, William Albert Winterrose, Sandra Sulcer, David Orville Kynaston, Mercedes R. Kipe, Carla Welling, Hal Wilkin, Joseph Eugene Wilkin, Norma Jean Miller Bach, Leslie Wilkin, Roscoe Craig Wilkin, Vita LeRae Wilkin, Alan Rudolph Wilkin, William Van Tessel, and Mary Elizabeth Van Tessel. And except as I will address shortly, either no Utah probate of the estates have been initiated, or if filed, they are incomplete and that there has been no proper distribution made to the heirs or devisees. Further, except as I will address shortly, although based on heirship affidavits and other inquiries and research done by OVINTIV's lease broker, Lone Wolf Energy Incorporated, OVINTIV believes it or other voluntary pooled working interest owners have leased all of the successors without an order from a Utah court confirming their succession. The possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore OVINTIV seeks to compulsory pool their interests and declare them non-consenting owners.
Okay, now referring your attention to Substitute Exhibit J, which is the proof of publication that was provided by the Uinta Basin Standard to these unknown, unlocatable heirs or successors. Did you ever receive any response from any of them?
I did not.
Okay. Are there any other information that the board needs to know about successors to these decedents?
Yes, as to the estate of William Van Tessel and Mary Elizabeth Van Tessel, just over a week ago, we were provided a copy of an order determining heirs entered to the record of Duchesne County on January 11th, 2023. The order was actually entered on December 23rd, 2022, and it established the heirs for the following parties, or for William and Mary Elizabeth Van Tessel, and the following parties declared therein were, that were unleased as to OVINTIV or any of the other working interest owners are Kevin Ronald Chatwin, Jessup William Van Tessel, Eileen Johnson, Merrill Chugg, the heirs of Gail D. Van Tessel, Kevin Ronald Van Tessel, the heirs of Owen Earl Van Tessel, and Catherine Ivy. However, notwithstanding the receipt of the order, because none of them timely responded to the publication or published notice concerning the deceased Van Tessels, OVINTIV would request that these parties be deemed non-consenting owners.
All right. Now turning your attention to Exhibit K. Again, that's a large document, and we'll be referring to just portion of it on the PowerPoint. Was that document prepared by you?
It was.
All right. Would you please outline what it is?
Sure. That's the joint operating agreement here. It's a form utilized standard to the industry supplied by the American Association of Professional Landmen. It's Form 610. This is the 1989 version with modifications to address horizontal wells. It's materially the same form JOA sent with the mailed notice of opportunity to Mr. Grant just outlined. And its terms and conditions contained therein, including the modifications made, are consistent with and commonly found in more recently developed horizontal well drilling units, including the JOAs signed by other voluntarily pooled working interest owners in this DSU. OVINTIV has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, Javelin, and other major Uinta Basin operators.
All right. Do you see the PowerPoint, the highlighted portion of Exhibit F?
I do.
Okay. Excuse me, this is K. Exhibit K, this was mislabeled. I apologize for that. On the highlighted portion, would you please show or explain what that is?
Sure, that's page 7 of the JOA, showing the non-consent penalty being 100% and 300%. And it's the same contained in the JOA signed by the other working interest owners in this DSU.
Okay, I'm confused here. This is the joint operating agreement that's attached as part of Exhibit F, is what we're talking about. It's also shown as Exhibit K. So I apologize for that confusion. Okay, now turning to the next page, do you see that highlighted portion?
I do.
All right, and could you explain what that is?
Sure, this is Exhibit C of the JOA, being the COPUS accounting procedure. This is, again, standard industry form, almost universally utilized, and is similar to other JOAs in the Uinta Basin. Page C3, Article 3B, sets out the interest rate at the prime rate published in the Wall Street Journal, plus 3%, which is fair compensation, and is to encourage timely payment of chargeable costs and expenses.
All right, now turning to the final page on the PowerPoint here. Again, you see the highlighted portion there?
I do.
And would you please explain to the board what that shows?
Sure, that's page C9 of the accounting procedure, and it outlines the overhead charges.
All right, is it your expert opinion then that the terms and conditions of this proposed joint operating agreement are fair and reasonable and consistent with those accepted by other working interest owners in this drilling unit and with those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
Yes, that's correct.
All right, just to point out to the board too, again, the Exhibit A requires modification to include Mr. Grant's specific contract area as determined by this hearing, and also if and when a party claiming buy-through or under one of those decedents that's not already leased or participating is discovered. All right, turning to the average weighted landowner's royalty, again, the statutory requirements provide that a compulsory pooled unleased owner is entitled to payment of the average weighted fee interest during the payout period, which does not include state, tribal, or federal leasing. Mr. Lair, I'm going to show you now what has been marked as Exhibit M. This is a three-page exhibit. Would you please, was this prepared by you?
Yes, that's correct.
Okay, please explain what it shows.
So it reflects the calculation of the average weighted fee landowner's royalty for the DSU as of the data spud of the Allen well. It includes the royalty provided for in lease form Exhibit B to the signed JOAs as related to OVINTIV's unleased fee interests in the DSU. And as Mr. McDonald said, it's showing that the calculation results in a 16.8672318% average weighted fee landowner royalty.
All right, Mr. Lair, I'm going to direct your attention to the certificate and supplemental certificates of mailing. These are pleadings that were prepared by my office and are on file on this. Do you have those in front of you?
I do.
All right, and do you recognize the people that are shown on that?
I do.
And who are those people?
Those are all of the production interest owners within the DSU. The addresses were derived from the title opinion effective as of July 22nd, 2022, and is updated by a search of the county records by Lone Wolf and OVINTIV's internal records.
All right, and members of the board, I'm going to point out Exhibit Z is supplemented, is relevant to Mr. Grant, reflects the certified copy of the mailing of the request for agency action was confirmed received by him. With that, that concludes my examination of Mr. Lair.
Division, any questions for this witness?
Not for this witness.
Board, any questions for this witness? Then back to you, Mr. McDonald.
Thank you, Mr. Chairman. With that, I'll commence my examination of Mr. Brown. Mr. Brown, would you again state your name and business address for the record?
Yeah, it's Kendall Brown, and the business address is 4 Waterway Square, Suite 100, The Woodlands, Texas, 77380.
And again, what is your position with OVINTIV?
Reservoir engineering manager, specific responsibilities to the Uinta Basin.
All right, I'm going to show you what have been marked as Exhibits O through Q. Do you recognize these exhibits?
Yes, I do.
And were they prepared by you or with the Ovintiv personnel with your review and input?
They were.
Okay, turning to, excuse me, let's start with Exhibit M, excuse me, too, as well. No, I'm sorry. I've got my notes mixed up. Exhibit O, please explain what that shows.
Exhibit O shows the cumulative capital costs and operating expenses through October 31st, 2022 related to the Allen 7H well.
And how did that compare to the estimated costs that it was sent with an AFE along to Mr. Grant?
The costs incurred were reasonably within variance of the original AFE, which I'll describe more in the risk assumptions.
All right. In your expert opinion, then, were the costs fair, reasonable, and necessary, and was the well deemed economically feasible to drill, as that term is used in the 13009 order?
They are.
All right. Could you address right now for the board what is the estimated plugging and abandonment cost for this well?
Ovintiv's current estimate is $75,000 per well on a gross basis.
Now, turning your attention to Exhibit P, would you please explain to the board what this shows?
Exhibit P is showing only horizontal wells in the immediate offset vicinity to where the Allen well was drilled at the time. You can see here that there is not as many horizontal wells drilled in this particular area as some of the other matters we've covered. And the Allen was the first long lateral horizontal drilled within its existing unit.
Now, turning your attention to Exhibit Q, would you please explain to the board and go through this point by point?
So Exhibit Q is describing the risks of drilling and completing this particular well. As Mr. Lear testified to earlier, there was quite a few vertical wells existing in this unit that were in close proximity to this particular long lateral horizontal that was drilled in the Uteland Butte Formation. This particular well was drilled into the Uteland Butte, like I just mentioned, which has instability issues with clay content that can cause collapse of the hole and sticking of drill pipe. Further to that issue, that is the exact issues that we did encounter on drilling the Allen 7H. Throughout the drilling process, we noticed quite high torque while drilling. This is kind of indicating that the hole is falling apart on us. The cuttings were not fully coming out of the hole. This resulted in our entire bottom hole assembly and drill bit, et cetera, to become stuck in the well. We were unsuccessful at being able to pull that out of the well and had to cut it off, set a plug, and re-drill the entirety of the lateral, which resulted in our drilling costs being slightly more than $1 million more than the AFE.
All right, in your expert opinion then, for those reasons, do you feel that a 300% risk assessment award is justified?
I do.
With that, Mr. Chairman, that concludes my examination. Mr. Brown.
Thank you. Division, any questions for this witness?
No questions.
Board, any questions? Yes, Mr. Moon.
Just another curiosity question. So you drilled past multiple vertical wells. Is there any way to estimate the reduction in production on this this horizontal well because it was drilled in close proximity to those vertical wells? Or lower pressures as you drill? I mean, any way to just your thoughts on that?
Yes, for this particular well, we actually didn't encounter any pressure losses while drilling this well. A lot of the vertical wells drilled in this particular unit are not actually Uteland Butte producers. Most of those are producing out of shallower formations. So in this particular unit, there was no observed pressure depletion that we observed.
Oh, so the vertical wells weren't even drilled to the same depth. Is that what you're saying?
Some of the wells are drilled to the same depth, just not all of them.
Okay.
So some of the wells that are Uteland Butte are not, they may be thousands of feet away or so, where we wouldn't expect pressure depletion.
Okay, thank you.
Any other questions? Back to you, Mr. McDonald.
Thank you, Mr. Chairman. That concludes our presentation in chief. At this time, again, I'll go very slowly because of the other matter. I would move for admission of Exhibits A through F, substitute Exhibit J, Exhibits K, M, O through P, and that portion of Exhibit Z is supplemented relating to Mr. Grant. The remaining exhibits relate to International Petroleum and will be addressed at next month's hearing.
Any objections to the admission of those?
No objections.
Any concerns from the board?
Oh, yes, you're right, I'm sorry, Q. It should be O through Q.
O through Q, huh? So it's A, B, C, D, E, F, G?
No, substitute,
Oops.
substitute Exhibit J is the next one.
Substitute J, K, M, O, P, Q, Z, Z supplemental. Huh?
Z
Portions
supplemental
of-
as relating to Mr. Grant.
Yes.
Yes.
Okay. Yes, Mr. Moon.
Finish that or?
No, I think that was, we're very, is it
So,
pertinent to this issue? Oh, okay.
So, for Mr. Lair, does Mr. Grant, did you have a conversation with him? Does he understand the consequences of being force pooled and what's going to happen? Or did he just not respond?
Yeah.
He did not respond to any of our brokers' communications. At the time that we were drilling this well, both he and his sister owned the entirety of track 24 on the plat that we had shown. And so we were actually able to get his sister to lease prior to spud of this well. And Mr. Grant, since being contacted at the same time, has never been responsive, not only to the notice that we've shown as an exhibit, but as to any prior attempts to lease him.
Okay, thank you.
I just need to close out the one item. All those exhibits are approved for formal entry.
Thank you, Mr. Chairman. With that, I'll just save a closing remark after the division's presentation.
Yeah, the division is supportive of the request being asked in this matter, and the remaining issues will be resolved, hopefully between the parties, if not by next month's board hearing.
Yes, let's hope so. Any questions for the division from the board? No? Mr. McDonald, any further?
Just again to state that as to the non-consenting owners, we believe that all the statutory and regulatory requirements have been satisfied. We would ask that the amended request as to those non-consenting owners be approved. And again, we thank the board for the long day and the attention, and again, for allowing the witnesses to appear virtually from Houston.
Good. Should I entertain a motion, or do we need to go leave the room for a consultation?
Ready for a motion?
Okay.
So I would move that we approve this request for agency action as to the non-consenting owners.
Second. Any last comments from the board? Seeing none, all those in favor say aye. Aye. Let the record show that was unanimous. Please prepare the appropriate documentation.
I will. Thank you, Mr. Chairman.
Thank you. And we are now on to the final item on the agenda, which is the discussion of cessation of annual reporting requirements and final determination of sunset provisions in pilot project spacing orders. This matter is actually continued until the February 2023 regularly scheduled Board of Oil, Gas, and Mining public meeting. We have our best minds on it, and the board will order detailed protocol and procedures will be forthcoming. We're aware that that there are some orders that the sunset provision is actually coming up fairly soon, and that there are also annual reporting requirements that are imminent. But again, I just want to stress that this has all been stayed until the February 2023 meeting. And I believe that concludes that matter for now. I would entertain a motion to adjourn.
So moved.
All right, we're out of here. And off the record.